Audio. Good morning, ladies and gentlemen. My name is Judge Lal. I think everyone is here. Okay.
Morning, Your Honor.
Good morning, Deputy Milton. All right. I have Mr. Jordan in the courtroom, and okay, let us begin. As I was saying, my name is Judge Lal, and this is going to be the Fulton State All-Purpose Calendar. These are criminal misdemeanor cases in which individuals were already accused of these charges by the Solicitor General's Office of Fulton County. They have been given an initial appearance in most cases. A bond has already been established in these cases. And what we are addressing today are possible plea hearings in which the defendants may choose to enter a plea of guilty or no contest to the charges in exchange for a recommended sentence. Certain other cases, the defendant may enter a plea of not guilty and the case will be further noticed for trial. That is what we call the arraignment process. If you are an accused, please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. And if you cannot afford one, we have counsel from the Public Defender's Office or the Conflict Defense List to represent you. Deputy Milton, who are the two cases that you have in your court, in your room?
I have position 1 and 2, Ms. Anderson. And then on the competency calendar, position number 10, Ms. Felisa Mack.
Okay. All right, let's address Jessica Anderson first. Is that who we have? Are you Miss Anderson?
Yes, ma'am.
All right, Miss Anderson, my name is Judge Lal, and you've been advised of your right to remain silent. And your attorney is going to be Mr. Findling. Miss Anderson, you have two cases with us.
Uh-huh.
All right. The first one is 22 CR 004-261C, in which you were charged with theft by shoplifting from October 31st, 2021. The second case is 22 CR 004-262C, in which you were accused of criminal trespass and theft by shoplifting from February 24th, 2022. With regards to both cases, you're represented by Mr. Findling. And Mr. Findling, what's the announcement for both cases?
Yes, Judge, and good morning. These are going to be a negotiated plea on each.
All right. Ms. Anderson, if you please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right. Ms. Sari, good morning.
Good morning, Judge Law.
And what is the recommendation for Ms. Anderson in both cases?
Yes, one moment, please. The state's recommendation is 12 for the first case, date 10/31/2021, is 12 months to serve 28 days. Credit for time served 14 days. The balance probated, an anti-theft course, and stay away from the Walmart located at 844 Cleveland Avenue in East Point. And that's to run concurrent with case number position 2, date of incident 2/24/2022.
All right, thank you. Mr. Findling, are those the terms?
Yes, Judge, it is our understanding of the terms at which we do agree. And I would just ask that on behalf of Ms. Anderson, the probation fees could be waived as finances are a big issue in her life.
All right. She'll be pleading guilty to 2 counts of theft by shoplifting. Is that correct? 1 in each case?
That's correct, Judge.
All right.
That's correct.
And pre-trial, do we have any prior theft by shoplifting convictions for Ms. Anderson?
I don't see any conviction.
All right, thank you. Okay, Ms. Anderson, and sorry, Mr. Findling, you stipulate to the factual basis and venue and ID for both cases, yes?
Yes, Judge.
All right. Ms. Anderson, first of all, have you consumed any kind of medication or alcohol recently?
No, I just took a Tylenol.
I beg your pardon?
A Tylenol.
Okay, but have you been able to understand the proceedings as they've transpired so far?
Yes.
All right, and have you understood and are you satisfied with your
Yes, ma'am.
attorney, Mr. Findling?
Yes, ma'am.
Is anyone forcing you or inducing you to take this plea today?
No, ma'am.
And has it been explained to you that if you incur 3 or more theft by shoplifting convictions on your record, that any future arrest it will automatically be a felony charge?
Yes, ma'am.
All right, so do understand that at least you'll be getting at least 2 convictions on your record today.
Okay.
All right.
Yes, sir.
If you decide to take this plea, you will have to waive your rights to go back to court and have a trial in a court of law. You will not be able to confront your accuser, examine witnesses, have the state try to prove the case against you beyond a reasonable doubt, and your opportunity to examine witnesses and present your own defenses. Are you prepared to waive these rights?
No, I'll take whatever he gives me.
If you don't waive these rights, then I have to disregard the plea and settle the case for trial. But if you
Okay, I'll waive him. I'll waive him.
Ms. Anderson, she's just asking you how we talked about by taking a plea, you're not going to have a trial. That's just what.
Okay. Okay.
How do you plead to 1 count of theft by shoplifting from October 31st, 2021?
Guilty.
How do you plead to 1 count of theft by shoplifting and 1 count of criminal trespass from February 24th, 2022?
Guilty.
I'll accept your guilty pleas. Your sentence is going to run concurrent for both cases. And the sentence is 12 months to serve 28 days, credit for time served 14 days. If you have no other cases holding you at the jail, you should be released within 24 hours and you must report to your probation officer next Tuesday. Do you understand?
Yes, ma'am.
The address is 132 Mitchell Street in Atlanta, Georgia. While
Okay.
you're on probation, you will complete an anti-theft class at your expense, and that must be done within the first 6 months after being released.
Okay.
You are to stay away from the Walmart at 844 Cleveland Avenue in East Point, and I guess was it the same location for both cases?
Yes, Your Honor.
All right. Just to give you some advice, Ms. Anderson, Walmart tends to send your picture to all their stores. So if any Walmart store asks you to leave, you would have to do so.
Okay. Okay.
All right. You're required to stay away from the one in East Point, but your picture will be sent to all the Walmart stores.
Okay.
And if they recognize you and they ask you to leave, you must leave.
Right.
All right. You must report to probation every month for the remainder of the 11 months you have in this case. All your probation fees shall be waived. Thank you.
Okay. Thanks.
You're welcome.
What's next?
Yeah, next case, and I believe it's
Is the composite calendar, position number 10, Ms. Mack.
all right. Mr. Jordan, is Mr. Walker and Mr. Howard available?
Yes, Judge, I'm here.
Okay, and did you want to address this in the breakout?
Yes, Judge.
All right. Deputy Milton will be with you shortly. Is Mr. Walker available as well?
I'm here, Your Honor. My computer is down, but I'm on my phone.
Okay. Mr. Jordan, could you place me, Mr. Howard, and Mr. Walker in a breakout room, please?
And I believe if Kasha's on the line, you can put her in as well. It's Amin Williams.
All right. Kasha, if you are on the Zoom, could you please sound out your presence? I don't think she is.
Okay, we can go without her.
All right.
All right.
Mr. Jordan is in courtroom 2, so I'm just going to wait until he places me in a breakout. Who's hosting, by the way? Is it Mr. Jordan?
Yes, he is, but I'm also co-hosting, so I put us in the breakout room, Your Honor.
Thank you, April. Thank you. All right. With regards to Ms. Mack, I've spoken to your attorney, Mr. Derek Howard, and he is making arrangements to have you transported to the Cavalry Refuge Center with the appropriate requirements, and that transportation will be arranged for next Wednesday on July 20th at I don't know what time, but it'll be next Wednesday. Okay?
Okay.
All right, and your bond has been amended to a $6,000 signature bond through the jail with a stay away from the incident locations. So the locations where you're arrested, you cannot return to those locations, all right?
Okay.
All right, that concludes your case. Thank you.
Your Honor, good morning. This is ASG Tortorello. On the Fambro case, the witnesses are present to testify. I believe it's going to be a bond hearing. And most of the victims in this case are ADAs. So I don't know if we could bump this case up.
I have no control over that. It looks like courtroom 2 is just about to fill in. And what position is Fambro?
I believe he's position 19.
Okay.
And I did send a message in the chat that I needed to speak with Mr. Fambro, if I could over the phone or.
Yeah. Do you have the jail number 404-612? I'm just blanking out right now. Was it 2392? Yeah.
Okay, so I can call that number now.
Yeah. Well, as soon as he's in the courtroom, you might want to wait till the deputy has filled up courtroom 2. Looks like they're just beginning to populate courtroom 2. And Mr. Spisman, who is your client?
Hey, Judge, good morning. It's Darian Benjamin. We have an offer on that case that we're probably not going to be able to accept. We'd just like to be heard on a slight bond reduction. It shouldn't take but 2.5 minutes.
You said Benjamin?
Yes, that's right, Your Honor.
Okay. And are you going to file a waiver of arraignment so I can just go ahead and further notice the case for trial?
Absolutely, Judge. That's no problem. I already spoke to Judge Dixon, case manager, Ms. Cook. So we'll get that filed immediately.
All right. Thank you. Okay. I'm not sure. I'll find out from Deputy Francois who are in courtroom 2 so that I can address those cases.
Good morning, Judge. I have, first person is Mr. Lewis. We'll find out what position he is.
All right, I've got a special request, Deputy Francois, from the attorneys. One is position number 19, Fambro. His attorney wants to speak to him on the phone. Is he in the courtroom?
Okay.
Okay, I can't really hear. Norris is on the phone with the attorney.
Okay.
No. All right. Do we have Fambro? Okay, the attorney needs to speak with him.
Okay, and also we've got a lot of witnesses who want to testify in regards to the Fambro case, so that's why we need.
Yes, we have him here in courtroom too.
All right, he needs to talk to his attorney first.
Yeah, he needs to talk. Pull him out.
All right, so
She said,
all right, so I'm hoping that his counsel will call the courtroom.
I can go ahead and call.
All right, thank you. And then the other one is position 6, which is Mr. Benjamin. We can take him after Mr. Lewis.
Judge, we're getting him now. So did you want to continue on with the next?
Yeah, whoever you have ready right now.
Okay, Mr. Gales. We're just walking in. Come on, Mr. Gales.
And Your Honor, I put in the chat that I need to speak to Mr. Gales.
All right, so hold tight, Mr. Gales.
All right, so Miss Helen, you'll be next in line to call the jail to speak to Mr. Gales.
Understood, Judge.
All right.
If Helen's available, got Mr. Fields, position number 20.
I also need to, oh, Mr. Fields is fine. I'm ready for position 20, Your Honor.
All right. This is position 20, case number 22 CR 004-361C, State versus Shaquan Fields. Are you Mr. Fields? All right. Looks like he's nodding his head. Was that a yes? All right. Mr. Fields, my name is Judge Lal, and this is going to be the all-purpose criminal calendar. You have a right to remain silent. Anything you say about the facts of your case, your statements can be used against you. You have a right to an attorney, and representing you is Ms. Catrice Helen. Mr. Gales is going to enter a plea of not guilty and have the case scheduled for trial. Shall I waive a reading? Excuse me, are you going to waive a reading of the accusation?
Yes, Judge.
All right. So Mr. Shaquan Fields, you're represented by Attorney Helen, and I understand that you want to enter a plea of not guilty to the charge of simple battery against a police officer or detention officer. I just need to let you know that this is a misdemeanor charge allegedly occurring on January 29, 2021 in Fulton County, Georgia. Upon your entry of a not guilty plea, the case will be scheduled for trial, at which time the state, the prosecutor, would have the complete burden to prove the charge against you beyond a reasonable doubt and overcome your legal presumption of innocence. If you, at the time of the trial, if the state carries its burden of proof, then you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
All right, sir. Your case has been arraigned and it's further notice for trial. Is there anything else to address?
No, Your Honor.
All right. Thank you, Mr. Fields. Your case is concluded. Courtroom 2, who do we have in the chair?
This is Mr. Lashtrap. Just to let you know, Judge, everybody that's in here, we want to do them first because they're actually on quarantine. So
Okay.
we want to get them out. We don't want to mix them up with the other guys in the back.
That's perfectly fine. Those were just special requests, and I'm going to place your request first. So this is an announcement to all the gentlemen who are in courtroom 2. Good morning. My name is Judge Lal, and we're going to be addressing each of your cases on a one-on-one basis. Please remember that you have a right to remain silent. Anything you say about the facts of your case during the course of this virtual and recorded proceeding, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, we will have counsel from the Public Defender's Office to represent you or attorneys from our conflict defense list. And I heard Lautrec, could you repeat that name again?
It's Lastrap, position 27.
Thank you. All right, this is Andre Lestrade. Is that
Judge,
correct?
Position 27 was also one that I needed to speak to, Your Honor.
All right. Do we have any cases from positions 1 through 19 in courtroom 2?
All right, thank you.
That would be Mr. Findling's cases. All right, Mr. Lestrade, you need to sit back because
Wait, hold
your
on.
attorney needs to speak to
You gotta
you.
go back in the back tank. Go back in the back tank for me. You're Mr. What? Yeah, you gotta go back in the back tank for me.
And
All
Judge,
right.
I can call now if that works.
I don't know if Ms. St. St. Flex, are you done?
Yes, I have finished speaking with Mr. Fambro. He does not want to have the bond hearing. He's gonna move forward with the plea with Mr. Finley. And I think I just text Mr. Finley that.
All right. Courtroom, we're going to address Mr. Fambro and Francois, the gentleman in Lestrade. He's going to talk to his attorney, Catrice Helen.
Yeah, that's the problem, Judge. We don't want to mix the other guys up with this. So what about position? So I have position 21, Mr. Flowers. So what positions can we do that I have out here?
I can do anyone from 1 through 19 right now. Or let's see now, who do you have in the courtroom that Miss Helen can address? Because she wants to talk to her clients.
We have Randy Gales, Mark Henry, Shakira Jackson, Keelan Lewis, Nico Flowers, and Andre Lestrade. Those are the ones we have in here right
Okay,
now.
Miss Helen, of those are clients, who can you address right now?
Judge, those are the individuals I needed to call. They were all on one floor and they were not made available to me at the jail yesterday.
So you need to
Because they were
talk-
all in quarantine.
Oh, did not get that note yesterday, but
All right, so you're not prepared to address any of them?
no, Your Honor, I need to speak to those individuals.
All right, Francois, what do we do? She needs to talk to everyone in that courtroom.
All right, so we gotta
Yeah, we're
do a
just
swap
gonna-
out.
Okay.
Yeah,
Just
but
give me-
they're not gonna be able to.
Can we do the South Annex while they're talking, Judge? I see the South Annex is logged on. I'm not sure who's at the South Annex.
We just addressed 2 cases at the South Annex, so if they have more, I'll be glad. Francois, just let me know when you're ready in courtroom 2, okay?
Yes, Judge, you're just gonna have to go to another court or South Annex, and then that way she can just, Helen can talk to all the people that's in here now.
Okay. All right, Ms. Helen, go ahead and call courtroom 2 so you can start talking to your clients one by one in courtroom 2. And Mr. Spisman, we're just gonna have to place you on hold. I don't believe your client's in quarantine, so they're gonna have to wait till they bring him into a clean courtroom.
Judge, that's fine. I mean, we could also, if you'd like, Your Honor, entertain the bond reduction and that may just resolve what we need to deal with here.
Do you want to waive your client's appearance for the bond hearing?
I'd imagine that he'd prefer for me to deal with this than wait. I think it's a pretty straightforward situation, I think.
All right, so if you want to waive your client's appearance, then I'll accept that. And so in order to expedite the bond hearing, is that what you want to do, Mr. Spisman?
I'd like to do that, Judge. And he also has a family member on, Ms. Giovanna Murray, so she can report back to him to ensure that everything went according to plan.
All right, what's the relative's name?
Giovanna Murray, Your Honor. She's muted and with no video on right now.
Ms. Murray, if you could start your video and unmute yourself, please. Oh, I do see her here, but she needs to unmute herself, okay?
Okay.
Okay, let me.
Yes,
see.
good morning, Judge.
Is that Miss Murray?
It is, Judge.
Yes,
All right, you need to start your video, Miss Murray.
yes, ma'am, one moment. Oh, let me start my video. How do I start the video?
Unable to access camera, allow Zoom to access your camera. Go into your, you're unable to access, so you have to open up your privacy Zoom on Zoom. Zoom and give it access to the camera.
All right, Mr.
Bisman,
we are addressing case number 21 CR 001-632C, State versus Ladarian Rodriguez Benjamin. Mr. Benjamin has been accused of reckless conduct allegedly on April 5th, 2021. In this present case, looks like he was arrested on a bench warrant back on May 31st of 2022. I'm assuming he currently has no bond.
Judge, he actually does have a bond.
4,000.
Yes, Your Honor.
All right. All right. No, it looks like it's been, he made bond back in April 7, 2021, and he's now got a $2,000. Yeah. I'm really confused. I see a $2,000 cash bond.
We were told, Judge, by the jail that it was a $4K cash, which the family's not capable of making. And that's why we're just simply requesting the court to consider a bond reduction, which I have some facts that might be relevant for that.
All right. So let's see. And you are stating that you are waiving his appearance for purposes of this bond hearing, because I have no idea when the jail is going to bring him out.
That's right, Judge. We are for that purpose, Your Honor.
All right. Okay. And who is the prosecutor in this matter? Is it Ms. Sari?
Yes, Your Honor.
All right. Okay. All right, Mr. Spisman, I'm listening. Please proceed.
Thank you, Judge. And my understanding, based on the information I've received from his family, is that Mr. Benjamin has no prior criminal history. This is a first offense. Obviously, he was arrested and thereafter made bond and was released. He, at that point in time, moved out of his grandparents' house, found some stabilities, and the grandmother, who actually assisted in retaining my services, just never told him that he had mail. So there was a bit of an error in communication. Nonetheless, he had just started a new job, Judge, on the day of this arrest for the bench warrant at El McCoy Construction. And he was arrested on his first day. Judge, he's currently living with his girlfriend, Miss Murray, who resides in Lithonia, very close to Fulton County. And he was also attending college at Talladega College in Alabama last year during this time period. So he was a student at school when he missed this initial court date. So while notification was sent to the address on file, it was not relayed to him by his grandmother's. Grandmother's obviously, Judge, elderly and not of full health. So because of financial issues, Judge, with his financial aid related to this initial arrest, he was not able to continue his education at Talladega. So he returned home and he secured a full-time job. He obviously has been able to retain my services on a limited basis, Your Honor. And I'll be frank with the court that I reduced my fee to much less than it normally would have been because of the financial concerns that the family had. What we're asking for, Judge, is we're asking for a fair opportunity to defend these charges. The state's offers 12 months to serve. So there's really nothing I can negotiate on that. It is a misdemeanor. What I found is the reason why the offer is that sort of offer is because of the allegation of there being a firearm involved.
Well, not just a firearm, but the allegedly being discharged and striking someone in the leg.
I understand, Judge. I do get that. But I have seen in the past 2 years, every firearm charge being a 12 months to serve offer. And the simple request, Your Honor, is for it to be a $2,500 good bond and allow him to post a bond using a bonding company. I've already contacted Ms. Cook I've already contacted Judge Dixon. I've attempted to contact Mr. Walker with the solicitor's office prior to today's date. And so we've done everything we possibly could do to try to right this ship, but we think that just reducing the bond to a $2,500 good bond would allow him to post that bond, return back to Lithonia, and have the opportunity to defend these charges. My understanding is there's no previous FTAs outside of those related to this particular matter.
Well, not quite.
Fair enough, Judge.
Not quite. So, okay, if you don't want me to get into it, I won't, but.
No, Judge, I understand that I'm relaying information that I received, and I understand that Tucson probably has provided the court with a very detailed level of information that I may not be privy to. So
And Your
please
Honor, I'll
correct
be
me where I'm
giving that
mistaken.
information as well.
All right, so let's hear from Mr. Tucson then, since Mr. Spisman clearly wants to hear from Mr. Tucson Howard as well. Tucson, are you available? All right.
Yeah, this computer's spinning slow. He had a 2020 arrest in Alabama for I put that in the chat for you.
All right.
He was arrested April for reckless conduct 2021, the initial arrest, and then July 6th, the FTA. That's all.
All right. And Ms. Sari, I'm familiar with the CWAC charge that's been brought against Mr. Benjamin. Other than that, do you have anything else to add to his GCIC?
Yes, Your Honor. In addition, well, I would like to add that there are 3 FTAs on this case specifically. The first one was for a plea and arraignment back on July 19th of 2021. The second was for a plea and arraignment back on October 18th, 2021, and then an FTA for a jury trial that was scheduled for 4/13/2022. So, Your Honor, this defendant has had multiple attempts to resolve this matter. He even had a jury trial scheduled, which he did not appear for. So he does present a significant risk of flight in the state's eyes. As you know, the allegations in this case is very serious. So we are asking the court to keep the bond as set. Again, the defendant has had multiple attempts to resolve the matter and multiple attempts to correct his address or to get notice. I'm sure at every court hearing he was informed that he needed to keep his address current. So the state feels as though he's had three chances to appear for his charges, and he just simply has disregarded them.
Okay. Mr. Spisman, did you want to call in your witness?
Judge, I don't need to call a witness. What I'd like to just suggest to the court, and I'm aware of this because I've participated in numerous state court hearings in front of Judge Dixon. He didn't show up and then not show up the next time, Judge. What the court was very kind to do is, and what Judge Dixon does is if you miss that first arraignment, it's reset, marked FTA. So it's all of
no.
this.
Yes, I do understand Judge Dixon's practice in this, and I didn't make a note that she didn't issue a bench warrant until the third strike.
Sure, so he just never got any note. I mean, it's consistent with obviously what
he didn't get any notice because apparently his grandmother didn't give him the mail. A grown man didn't check his own mail. Yeah.
Right, Your Honor. That is the defendant's
my question. Thank you, Ms. Sari. My question is: we have Ms. Murray, who's apparently a witness in support of Mr. Benjamin. Did you want?
Yeah, and I can have her briefly testify, Judge. Ms. Murray, if you can
unmute, please. Thank you.
Yes. Good morning.
Good morning, Ms. Murray. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
How do you know Ladarian Benjamin?
I've known him for maybe 3 to 4 years now. We are dating.
Okay. All right, Mr. Spisman, you may proceed.
Thank you. And Ms. Murray, I understand you've been dating Mr. Benjamin for 3 to 4 years. At this point in time, prior to this arrest, was he gainfully employed?
Yes, he was employed.
Okay, and what was he doing?
He was working at LM McCoy Construction. Well, it was his first day when he got arrested.
Okay, and that's a full-time job?
Yes, it is Monday through Friday.
Where's that located?
It's in Dunwoody. The site is in Dunwoody. They work on different construction sites, but the actual office is in Dunwoody.
Okay, and where does he live?
He's currently residing with me in Lithonia.
Okay, and he lives with you full-time?
Yes, that's correct.
Okay, and if the judge were to grant a bond, you'd be able to provide the court with a secure address for Mr. Benjamin and he can receive mail?
Yes, that is correct.
Okay, and in addition to that, before gaining a full-time job, was he participating in any type of educational program?
He was originally in Talladega College, so he was back and forth with being in college and then coming to reside with me.
Okay, and does he have any family members? I know you're not a family member, but you're probably soon to be one. Does he have any family members in the Atlanta, Georgia, Fulton County area or close to it?
Yes, he does have an aunt who lives in Atlanta as well.
Okay, and his grandmother, where's his grandmother reside?
She still resides in Alpine, Alabama.
Okay, and when he was living in Alabama, did he return to Georgia often?
Yes.
And would
very
he stay
often.
in Georgia? Would he stay in Georgia for extended periods of time?
Yes.
Okay, and I mean, obviously, you guys have talked about the case. I don't need to get any details about that, but I mean, at any point in time, was he ever aware that he had missed a court date?
No.
Okay, and is his grandmother? What kind of health is she in? I mean, is she, I would say, a reliable person to go to the mailbox and get mail and?
She's currently on disability, so she is sick. She does have a nurse that comes in and takes care of her in and out throughout the week. So, yes.
Okay. All right. Is there anything further that you'd like to share with the court related to Mr. Benjamin's ties to the community or likely to show up for court, things of that nature?
I can just assure the judge that he will be at court. He's currently permanently here in Georgia, so I can assure the judge that there won't be any more missed court days.
And finally, right now he is what we understand to be a $4,000 cash bond. Is part of the reason why your family retained my services is because he cannot make that bond?
That's correct.
Okay, and if the judge were to give him a $2,500 good bond, which you guys would be required to post somewhere around 15% of that, do you have the resources to do that?
Yes, sir.
All right, nothing further, Your Honor.
Ms. Sauer, do you have any questions to ask the witness?
No questions for the witness, Your Honor. I would just like the court to note that this witness is biased. She does have a relationship with the defendant, as well as the fact that it's not her responsibility for the defendant to show up to court. She cannot assure the court anything regarding his appearance. That's solely on the defendant, which he has exhibited 3 times that he would not appear.
Thank you. I'm sorry, was it Miss Javon? Is that correct?
Yes, Giovanna. Yes, ma'am.
All right. Where does his grandmother live?
She lives in Alpine, Alabama.
And is your street address Turnberry Place?
Yes, ma'am. That is my address.
Miss April, Miss Champion, has the Turnberry Place ever been, the Alabama address ever been listed on our Odyssey system?
Yes, ma'am.
Okay. I'm going to amend the bond to a $4,000 surety bond. Mr. Benjamin is not permitted to have any firearms in his place of residence, which I'm assuming is Turnberry Place. He's not allowed to have any firearms on his person, in the home, in the residence, in any vehicle that he occupies or anywhere near him. He's to report to court when summoned, and he is to make sure that he maintains all his current information with the court at all times, email, phone number, and so forth. So if he moves out of Miss Giovanna's place, he needs to make sure that he updates us with all his current information. Since Mr. Spisman, you are planning to file a waiver of arraignment, this case will then be deemed as arraigned and further notice for trial, which I guess it was back on April 13th, 2022. All right.
Thank you, Judge. And in due course, if that can be relayed to my client, I would certainly appreciate it.
All right. Please go ahead and submit the proposed order directly to April Champion. That's april.champion@fultoncountyga.gov.
Okay, Judge, I will do that momentarily.
All right. Thank you, Mr. Spisman. That concludes this hearing. Thank you.
Thank you, Judge.
Thank you.
Mhm.
All right, next we got number 9, Mr. Burgeon.
All right. Thank you.
Judge, whenever you're ready for courtroom 2, we're ready to start here as well.
All right. Thank you. We have Terrence Burgeon, case number 22 CR 0042288. Mr. Burgeon's alleged offenses occurred on June 29, 2022, and the charges of misdemeanor possession of marijuana, no automobile insurance, operating a vehicle on a suspended or canceled or revoked registration, and no proper headlights. Mr. Burgeon, you have a right to remain silent about the facts of the case. Any statements you make, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Zach Finling. Mr. Finling, we are going to arraign this case and have a bond hearing. Is that correct?
That's correct, Judge.
And you waive a reading of the accusations?
I do.
All right. Mr. Burgeon, I understand that you'll be entering a plea of not guilty to these charges. Upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the state would have the complete burden to prove the charges against you beyond a reasonable doubt. If the state prevails, you could be convicted and face a penalty of up to a year in prison and/or up to $1,000 fine for each convicted offense. Given this information, how do you plead?
Not good.
All right. Your case has been arraigned and it's further notice for trial. Mr. Burgeon was given a bond order on July 1st in the amount of $2,000. It was a surety bond. And Mr. Burgeon, let me see. Okay. All right. Yes, sir. Yes, Mr. Finley.
Yes, Judge. As previously stated, I am asking for a bond modification on behalf of Mr. Burgeon. Mr. Burgeon does have, as of now, a $2,000 surety bond, which he is unable to make good. As you can see, the charges are no insurance, the knowingly driving by motor vehicle while it's suspended. When he got picked up, Judge, it was for a warrant. He was never asked for his car insurance. Instead, he was immediately arrested and taken away. It was only thereafter that he learned he had these charges. The only problem is that he does have insurance, but he just didn't have the opportunity to show the policeman where it was at. He does have Geico insurance. He says, as of right now, that Geico information is sitting in his glove box, which obviously was not checked by the policeman. So, Judge, we are asking for a signature bond on his behalf. He does work 7 days a week for Instacart. He's a hardworking man, and he's a man that did not have the opportunity, as many people do, to show where his documentation was. So if he did, we would not be here with that specific insurance charge. So I am asking for a signature bond on behalf of Mr. Burgeon, Judge.
So does he have an outstanding case in an unrelated? Does he have an outstanding warrant in an unrelated case?
Yes, Judge. Yeah, he was taken in on something else, and he is being held on something else. But I just want these specific charges to be one less thing that is holding him. That's why I'm asking for it.
Thank you,
Yes, Judge.
Mr. Tucson, any prior traffic infractions, any prior suspended registrations or anything like that?
Let me see. You know about the open?
Yes, I do.
Superior Court case, right? Okay. All right, let me see. Now, state may have his driving history. I don't have a driving history.
All right, thank you. Ms. Sowry, do you have anything on Mr. Burgeon's driving history?
Yes, Your Honor. There are actually two open Superior Court cases. And for one, he has a case where it includes charges of no license and failure to signal. So there is history regarding driving infractions. And I would just like to state for the record, in the warrant, it did state that the defendant was operating a vehicle without headlights. That was the reason for the stop. When his tag was ran, it revealed that there was no insurance and no registration. So that was the reason for the charge.
Understood. All right. So with regards to these charges that have been given to Mr. Burgeon, let me just pull that up. Okay. On the possession of marijuana, that's going to be a 500 signature bond through the jail. No automobile insurance, that's going to be a $500 signature bond through the jail. Driving a vehicle with, well, it's all going to be a signature bond through the jail. That's a $2,000 signature bond through the jail. And conditions to the bond is that he must maintain current registration, current automobile insurance. Well, those probably, if the registration was not current, the insurance most likely would have been revoked by the DMV. And he needs to make sure that his driver's license is also current and valid at all times. And make sure that you comply with turning on your headlights when the sun goes down. That's simple, I mean, just common sense. All right, thank you.
And just want to verify, Judge, it was 500 on each, correct?
Correct.
Okay, thank you.
So I'm told one of these Fridays, we're going to have almost 24-hour daylight. So according to NASA, so you all keep that in mind. All right, thank you. All right, Mr.
Wait a minute, what?
Hey, Ms. Rockwell.
Can you say that again, Judge?
I've been told.
Please tell me what you just said.
I said on July 18th or some day, it's supposed to be 24-hour sunlight. So Ms. Rockwell, you have to be up all 24 hours.
Good. I
Okay.
can work all day. Judge, I'll stand down.
All right, thank you. Courtroom 2, good morning. Francois?
Judge, this is gonna be Mr. Fabro, position 19.
All right, thank you, Mr. Fambro. Okay. All right, good morning, gentlemen. My name is Judge Lal, and I'll be addressing all your cases on a one-on-one basis, including Mr. Fambro's. I'd just like to remind all of you that these are active criminal cases pending against you. So please remember to remain silent about the facts of your case. And because any statements you make during the course of this virtual recorded proceeding, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, we have counsel from both the Public Defender's Office and from our conflict defense list who are prepared to represent you. So I have Mr. Fambro. Thank you, Officer Norris and Officer Francois for making the individuals available. But Mr. Fambro, I'm sorry, I just need to get to his case number, which I believe is position number 19, was it?
That's correct, Judge.
All right. There we go. This is Lareco Fambro, is that correct? All right. Mr. Fambro's case number is 22 CR 003516Y. He has got 1, 2, 3, 4, 5 counts of terroristic threats brought against him from an incident on June 3rd, 2022 that occurred at the Fulton County Courthouse. Mr. Fambro, you've been advised of your right to remain silent, and your attorney is going to be Mr. Zach Finley. All right.
Your Honor, I can't hear you over courtroom 2.
Courtroom 2, we can go ahead and mute courtroom 2 at presently. Thank you. All right, Mr. Finling, I'm not certain. Okay, what are we doing? Ms. Tortorello, you had a lot of witnesses here today.
Yes, we expected a bond hearing, but it seems that the defendant is accepting the state's offer.
All right, so are we having a negotiated plea hearing?
So Judge, this is going to be a non-negotiated plea. Mr. Fambro did want me to inquire about first offender. And secondly, we are going to argue for time served as well.
All right, thank you. All right, Mr. Fambro, a non-negotiated plea hearing means that first we're going to have the state, the prosecutor, present their recommended sentence and provide the reasons why they're seeking that recommended sentence. In addition to their recommendation, they may also call upon witnesses to testify and to support their reasons for that particular recommendation. Then your attorney will provide the alternative recommendation, and I will then hear your criminal history record. Based on all this information, your attorney will also have an opportunity to present evidence to support your particular recommendation. After I've heard all the evidence, then I will make a decision as to which recommendation I will accept, keeping in mind that I also have a right to disregard either recommendation, disregard the plea, and have the case scheduled for trial. All right, so before we proceed with the defense, Ms. Tortorella, you may start.
Yes, Your Honor. And before I give the state's recommendation, I do want to state that Chief ADA Ernell Winfrey is present. She would like to speak, as well as ADA Simone Hilton is present as well. There are some MH issue concerns, Your Honor, so I don't know whenever these witnesses speak, I'm not sure at your discretion whether or not we should break out.
Well, go ahead. I'm going to allow that, and I don't need a breakout if they're coming from the alleged victims. Okay?
Yes, Your Honor.
You may proceed.
So for count one, terroristic threats, 12 months served, 90 days, credit for time served, 41 days, balance probated, 80 hours of community service, 88 weeks of anger management, and no contact with the victim, Ernell Winfrey. That, for the record, that's EARNELLE. The last name is Winfrey, WIN as in Nancy, FREY. Also no contact with the victim, Soroya Ward, and that's spelled S as in Sam, ORIYAH. Last name is Ward, WAR as in Robert D. No contact with victim Juliana Peterson. First name is JULIAN as in Nancy A. Peterson, traditional spelling. No contact with victim Siri Patel. That's SIRI. The first name and last name is Patel, traditional spelling. No contact with Simone Hilton. That's SIM as in Mary, O, N as in Nancy, E. Last name is HY, L as in log, T as in Tom, O, N as in Nancy. For count two, terroristic threats, 12 months served, 90 days, credit for time served, 41 days, balance probated. Again, no contact with the victims. Concurrent with count one. Count three, terroristic threats, 12 months served, 90 days, credit for time served, 41 days, balance probated, no contact with the victims. Concurrent with count two. Count four, terroristic threats, 12 months served, 90 days, credit for time served, 41 days, balance probated, no contact with the victim. That counts concurrent to count three. And for count five, terroristic threats, 12 months served, 90 days, credit for time served, 41 days, balance probated, no contact with the victim, and it's concurrent to count four. Nothing further from the state.
And how many days would he have to serve under this recommendation? How many more days?
I believe he just served 41 days, Your Honor. So if it's 90 days, it's up to the jail to decide whether they'll give him credit. 2 for 1, correct. Oh, and Your Honor, I need to go over the facts since this is non-negotiated. On June 3rd, 2022, a Black male later identified as defendant Wareko Fambro made threats towards staff members on elevator number 13 at the Lewis R. Slayton Fulton County Courthouse, 136 Fire Street in Atlanta. Staff members inside the elevator said defendant asked about their family members in a creepy way. Miss Ernell Winfrey said she got in the elevator to go to her office and was in the elevator with other staff members. Soraya Ward, Juliana Peterson, Siri
Just
Patel.
just one second, please. Mr. Fambro, replace your mask over your nose. Thank you. All right, go ahead.
Yes, Your Honor, and Simone Hilton. Miss Juliana Peterson said, and Miss Simone Hilton noticed that when the defendant entered the elevator and the elevator's door closed, the defendant did not press a floor button after she and the staff members did. Miss Peterson then asked the defendant what floor he was going to, and the defendant responded, where justice was served. Miss Peterson said, and Miss Hilton observed the defendant block, and this is actually also in the police report, Your Honor, that he actually blocked the elevator door with his body, faced the victims and crossed his arms. Miss Peterson advised the defendant, then said justice was going to be served today and that he would not stop until all of them were broken. Miss Peterson said defendant then began to ask about their families by saying, how are your children, your husbands? Miss Winfrey also heard the defendant ask each of the staff members whether they were good and whether their families were good. Miss Winfrey said the defendant appeared to not have a destination, and when they reached the 7th floor, she and the other staff members got off the elevator and the defendant got off behind them. Miss Winfrey and the other staff members immediately informed law enforcement of this man's presence on the 7th floor. The defendant's actions prompted immediate response from the Fulton County deputies at the courthouse, and all these events did occur in Fulton County, Georgia, Your Honor. Nothing further.
All right. Did you want to call any of the alleged victims? You said Miss Winfrey and Miss Hilton?
So if Chief, I don't know if Chief ADA or Miss Ernell Winfrey and ADA Simone Hilton would like to turn their cameras on. And Miss ADA Juliana Peterson's also on the line, Your Honor.
All right. Who would you like to have testify first?
The Chief ADA Winfrey, Your Honor.
All right. Miss Winfrey, I guess you're up first. Good morning.
Good morning, Your Honor. Thank you,
Ms.
Ms.
Please.
Absolutely.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right. Ms. Tortorella, you may proceed.
Yes, Ms. Winfrey. So could you describe what happened that day?
Yes. On that particular day, I came into work. I approached the courthouse to go to my office. I entered on the Pryor Street side of the Fulton the Fulton County Courthouse. When I entered the elevator, I entered in with my colleagues, Ms. Peterson, Ms. Hilton, Ms. Patel, and there may be a couple of other people in the elevator that got off prior to us getting off on the 7th floor. The defendant got in the elevator with us, and he seemed to be a little disheveled. I noticed that he seemed to be a little nervous. He did not push an elevator, a floor to go anywhere. So I was really very paying much attention to what he was doing. Others got off the elevator, and then it was just my colleagues and myself on the elevator, and he seemed to be shifty. He made some comments about justice being served. He made some comments about talking to us about what, how our families were doing, and it was very, very strange. He did not get off on any floor. He blocked the elevator door, and it was very unnerving. If I had not had my colleagues with me, I would have been way more afraid. But because I had my colleagues with me, I felt a little more secure, because safety in numbers is what I'm thinking. When we were able to get off the elevator, he got off the elevator on the same floor that we got off. He seemed to kind of be walking towards us and near us. And thank goodness we had our investigators kind of on that floor, and other folks that we could ask for assistance from, and we did just that and got into our offices and went from there. I don't know what Mr. Fambro's condition is. I think he has some other conditions going on that I would like the court to address. Should the court he take a plea in this case, I think he needs help in other ways. And in Superior Court, we would call it, ex parte matters. And I would ask the court to address that, because he seemed to be very disheveled, and it was very unnerving. I would ask he not come near myself and my colleagues. We want to come to work and feel safe. We want to come to the courthouse and feel safe. And that does not add to that feeling of safety to have Mr. Fambro act in the way that he did on that day. So I would ask the court to actually follow the recommendation of Ms. Tortellini, what she told the court today, but I also ask the court to consider putting some conditions in place that will address some of his, I guess, ex parte matters that I observed and feel that he has.
So can you describe to the court how he blocked the elevator door?
He turned his back towards the opening of the door and faced us.
Did you feel like you could leave, or what was the situation? How was he wasn't letting you get out of the elevator, or?
No, so of course we couldn't get out of the elevator when it was moving, but as the door opened, he was just standing there. I think again, because of the number of us, it was we were just kind of maneuver around him, but no, he was blocking the door.
Okay, and how did you feel threatened? Can you describe that a little bit more?
I felt scared that he was going to do something. I felt that he could have attacked us. He could have placed his hands on us. Thank God he did not. But the feeling that he could and would have, because of his whatever mental condition he has going on, it looked like he was just on edge. And so because of that feeling, I felt he could have done something, although he did not. But I did feel like he could have harmed us in that elevator.
Okay, and do you feel like he has MH issues, and why do you feel that way?
I guess based on my training and experience as a deputy DA and what I do in law, I've seen this behavior kind of before, and I just feel like he has some other issues going on that need to be addressed. I do not think that mere incarceration is going to help him. I don't know, but I feel like he needs to be evaluated. But he appeared to be on edge. He appeared to have something wrong with him. I think my colleagues would agree with me on that. And I think those issues need to be addressed so that he is not back in here doing the same thing.
Okay.
All right. Thank you.
Thank you, Ms. Winfrey.
Mr. Finling, did you have any questions to ask of Ms. Winfrey?
No, I don't, Judge.
All right, thank you. Ms. Peterson and Ms. Hilton, I would appreciate your testimony, but I'm just wondering whether it's going to be cumulative. So I'm going to ask Ms. Peterson, do you have anything else to add in addition to what Ms. Winfrey has felt or observed?
No, Your Honor, I think she summed it up pretty well.
All right, thank you. And Ms. Hilton?
Good morning, Your Honor. Same. I believe that DDA Winfrey summed it up as well.
All right, thank you very much. Ms. Tortorello, Ms. Winfrey, her name is Tortorello. I've made the faux pas of calling her otherwise a very delicious pasta, but
I'm sorry, Ms. Tortorello, sorry.
Yeah, it's okay. Ms. Tortorello, do you have anything else to add?
Yes, and hearing the witnesses and testimony and the fact that this is a non-negotiated plea, the state will add MHET to the offer, the defendant's offer. And also, Your Honor, I don't know if pretrial's on the line, so they could read the defendant's history on record before your decision is made.
All right, Mr. Tucson, any priors on Mr. Fambro?
This is 10th arrest. Last arrest was 2018 FTA for theft out taken. We had a battery from 2015. It just says bond over. 2012 marijuana possession NOD. Probation violation 2010 for theft by conversion. That's it for the most part. Yeah, that thought that was expunged from the 90s. Yeah, that's it.
All right, so that's pretty much the same record I heard when we established the bond. Mr. Findling, do you have an alternative recommendation?
Yes, Judge. So the state, Your Honor, is asking for the 90 days, which after the 2-for-1 would mean that Mr. Fambro would have to serve 3 additional days in jail. I'm showing as of today, he has served 42 days, Judge. Mr. Fambro is 40 years old. He does have a 13-year-old son, that he has not seen in 42 days, and a 13-year-old son that's about to begin middle school, and he definitely wants to be there for that. Mr. Fambro does work full-time. He works full-time in apartment maintenance at apartment complexes. Unless I've seen otherwise, he spends his time going in and out of individuals' apartments while they're there alone. And from what I've seen, I'm assuming he's never caught any charges when he's been alone with people in their own apartments. And while I do see, I believe I saw he had a couple felony convictions. Those were both 23 and 22 years ago. So, Your Honor, while I do appreciate the testimony we've heard, obviously the main thing we've heard is that he made them uncomfortable, and I do sympathize with that. And he spent 41 days or 42 days now in jail for making them simply uncomfortable. So I am asking, Your Honor, for time served. I think he has done his time, and I hope now he can get back to his son before he starts school. So asking for the time served, Judge. Thank you.
All right, thank you.
Your Honor, just to make clear, he did make a statement that he wanted to break them.
Oh,
yes,
and,
I've noted that in the allegations.
And
okay. Yeah. I've noted that in the allegations. You know, it's just a fact to be proven if the case goes to trial. But now we're at the stage of considering a non-negotiated plea. And whether Mr. Fambro, I've noticed that he kept shaking his head throughout the whole testimony. But one thing is undisputable, that he was in the elevator with these 4 other individuals. And apparently all 4 of them resonated the same experience, the same observations of the alleged defendant. And the fact of the matter is that they are all in the line of criminal prosecution. He is in a building where justice is rendered, and his alleged comments did place these particular victims with their particular vocation in an extremely unsettling position. And I do also appreciate Ms. Winfrey's comments and her observations as to perhaps an evaluation is warranted. I will accept the defense recommendation of to serve 42 days. So it would be to serve 88 days, credit for time served 42. No, to serve 84 days, credit for time served 42 days, which is the amount of time that he has served. That he will be placed on probation. He will report to probation every month. I will waive his probation fees. Within 30 days of being released, he will undertake an MHET, which his probation officer will explain to him. It's a health evaluation that you must undertake from the correct healthcare provider. And if the healthcare provider says that you must subject yourself to any kind of treatment or counseling, you must subject yourself to that treatment and counseling at your expense, but you will report to probation. You will not enter any of the courthouses at Fulton County without first consulting with the bailiff or the deputies or the marshals who are at the security gates at each entrance. You will tell them that you are only permitted to be in the building when you have a law enforcement escort, and you will carry your bond order. Wherever you travel within the Fulton County Justice Center complex, you must inform the security that you're required to have law enforcement escort to wherever you need to go to. But your entrance into any Fulton County courthouse must be for a legitimate reason. No alcohol consumption, no illegal drugs, no weapons, and no firearms. All right, Mr. Finling, that is the recommendation of the court. Is that something that your client will accept?
Mr. Fambro, would you like to move forward with the guilty plea, sir?
Yes, and then under that, this is all done under the First Offender Act for me. So once I'm through with the probation, that this.
I am not going to sentence you under first offender. This will be a guilty plea only.
Your Honor, to add, could you add no contact with the victims?
Oh, yes, I'm so sorry. It'll be no contact with the alleged victims unless they happen to be, well, Miss Winfrey, Miss Peterson, Miss Hilton, you know, if he's in a courtroom in which you are prosecuting, it will be difficult. Are you comfortable with no contact, or are we comfortable with no further violent contact? Ms.
Your
Winfrey?
Honor, for Simone Hilton, I mean, if it presents itself that we have to have a case against with him, it'll be no further violent contact.
All right. So it'll be no further contact with the 4 alleged victims, with the exception, with the exception of unless he's in the courthouse.
And Your Honor, one of them is not an ADA. Can we do no contact for her, please?
And that would be Siri Patel?
No.
Ward?
Hold on, Your Honor. It's Miss
Soraya
Ward.
Soraya Ward? Okay. All right. It'll be no further contact with Soraya Ward.
Your Honor, the reason why I was asking for first offender, because like I said, I'm an HVAC maintenance technician. So I have to deal with family members and wives and children. On my record, once I go apply for a job, you know, I didn't want that to show on my record as I'm a terrorist threat. I don't have anything on my record like that. The pretrial is pulling record that doesn't exist. It's like double jeopardy. He shouldn't even be looking at that. Those are sponge records, and I already don't handle that. And on top of that, that's why I asked for the first offender act. I'm not looking to go down there and start trouble with the ladies at the courthouse. I don't even know them like that.
All right. I understand.
That'll mess up my record.
I understand. Ms. Tortorello, do you have a response to the request for a first offender? It would be on his record while he's on probation.
1 second, Your Honor. Let me look at the background.
I never took my first offender act. I need that though, because I don't want that to mess up my record.
I know, sorry to cut in, not ASG Tortorello, but based upon the fact that he's already had an aggravated assault expunged, we absolutely will object to first offender. So that is the state's response.
I ain't never had no aggravated assault.
Obvious reasons.
I ain't never had no aggravated assault, y'all.
There's a react, to all of our decisions, and
all right,
that would just be a consequence of this plea or his decision.
So I never had an aggravated assault against me, and I never used the first offender on the aggravated assault charge, and I'm not a convicted felon.
Just 1 second. Mr. Finling, do you have a response, please?
Just the fact Mr. Fambro did want to use first offender. I obviously, do understand where ASG Walker is coming from, Judge.
I don't understand where he pulled that information up from.
Mr. Fambro, this is based on your birth date, your social security number, and your fingerprints, and based on your prior arrests. So you do have I'm not about to argue with you.
Mr. Fambro?
You do have a criminal history record. And even if I were to disregard the aggravated assault allegation, even if I were to disregard that, based on your current criminal history record, I will not accept a plea under the first offender. So final question. Do you want to proceed with the plea, or would you like a trial?
Well, I'm a man of faith, so I'll take it. It's okay.
Mr. Fambro,
All right.
man, if you could just be respectful, sir, but if you do want to move forward with the guilty plea, that's up to you. But if not, that's obviously perfectly fine. We can do that, and this can go to trial, sir.
I'll do the guilty plea and then do the probation and stuff. It's just a misdemeanor. And then once I get some help, it's okay.
All right. Mr. Fambro and Mr. Finling, do you stipulate to the venue and ID in this case?
Yes, Judge.
All right. Mr. Fambro, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
It is.
All right. If you could please sit back, please, sir. I can see you better that way. Thank you.
Oh, sorry.
All right, Mr. Fambro, in this particular case, you have been accused of 5 counts of terroristic threats stemming from a July 3rd, 2022 incident at the Fulton County Courthouse.
Yep.
First of all, I'm sorry?
June 3rd.
That's what I thought I said. I'm sorry, June 3rd, 2022. Yes. And with respect to these charges, we have already addressed the terms of the non-negotiated plea. And I've clarified with you that I will accept a guilty plea, not under the first offender status with respect to all 5 charges, and that I would give you a release with terms that you'll be on probation and that you would have to comply with certain conditions. First of all, have you consumed any kind of medication or alcohol recently?
No, ma'am.
And have you understood the proceedings as they have transpired so far?
Yes.
And are you satisfied with your attorney?
Not really, but I don't have the means to keep on fighting the case. I guess that, like I said, I'm going off what God want me to do. So I'm a God-fearing man, and I feel like that's the best interest for me. So I asked for the best thing. So I can't fight against the defense team, and I don't have the means of. That's the best thing I do. I just get out and apply with the probation and stuff and still look for me a job. I guess I have to explain that situation to the company that I work for.
All right, that was a rather long response, not really addressing. So if you're not satisfied with the representation of your attorney, we can always reset the case for your attorney to explain further the terms of a plea and whether you want to take a plea or whether you want to go to trial.
I'm satisfied.
And are you being forced or induced to take this plea today?
No.
I can't hear you.
I said no.
All right. And has your attorney gone over the plea sheets and the plea recommendations as well as the rights that you would have to waive?
Well, not this. Well, not
These
this.
I apologize. I'm going to interject. Given this wouldn't be even a time served plea, Judge, I think we need more time on Mr. Fambro. So I would ask the court to reset this to give us an opportunity to speak in more detail. With him.
Hey, Derek, just so you know, Derek, it is time served. I did argue for time served. And
oh, okay.
He will not be spending additional time. So let me.
But
hold on. Too many people talking. Okay. Mr. Fambro, pause. Do not say anything. Mr. Findling, apologize for that. Please tell. So may I continue with the plea narrative? Mr. Findling, may I continue?
You may, Judge. I was just telling Mr. Howard that it was time served, but I will default to what he thinks though as well.
All right. So again, Mr. Fambro, have you understood the discussion with your attorney when he went over the plea documents and explained to you the waiver of rights if you decide to take a plea today?
Yes.
And do you understand that by taking a plea that you will be waiving your constitutional rights? Mr. Fambro?
Yes.
Do you understand that if you take a plea today, you will be giving up certain constitutional rights to defend yourself in a court of law?
Yes.
Those rights will include the right to go back to court, to have a trial in front of a judge or a jury, to have the assistance of counsel so that you can challenge the state's evidence, present your own defenses, examine and cross-examine witnesses, confront your accuser, and have the state try to prove the charges against you beyond a reasonable doubt. Have those rights been explained to you?
Yes.
Are you prepared to give up these rights?
Well, yes, I got to comply with what the police say. So when I get out, I got to go to the probation and stuff, and then move on with my life. So yes.
If you listen very carefully, if you take this plea today and you're placed on probation, You will never have the opportunity to go back into a courtroom in a court of law and have a trial to challenge these charges. Are you prepared to give up these rights as I've just listed them?
Yes.
Repeat.
Yes.
And do you understand that by taking such a plea, it may have an impact upon your residence if that is relevant to your particular case? It may have an effect on any professional licenses that you may have and have an impact on other personal matters in your life?
I'm sorry, I didn't get an answer.
Yes, I do.
All right. And you're still willing to go forward with the plea willingly, knowingly, and intelligently?
Yes.
How do you plead to the 5 counts of terroristic threats stemming from a June 3rd, 2022 incident?
I plead guilty.
I accept your guilty plea. Your sentences will be concurrent with respect to all 5 counts. You are to serve, it'll be serving 12, it'll be 12 months to serve 84 days, credit for time served 42 days. If you have no other cases holding you at the jail, you will be released within 24 hours and you must report to the probation office next Thursday at 132 Mitchell Street. I will waive all your probation fees, but you must report to probation every month, and you cannot afford to get arrested again or fail to comply with any of the conditions of your probation. Otherwise, your probation will be revoked and you will spend the rest of the year in jail. Understood?
That's understood.
While you are on probation, as I said, you will report every month. You're not to possess any weapons or any firearms. You're not to consume any alcohol, and you're not to consume any illegal drugs. You will be tested by your probation officer. You will stay away from all the Fulton County courthouses or referenced as the Justice Center complex unless you have a legitimate reason to enter into any of the buildings. A legitimate reason would be if you're a witness, a litigant, or a party to any cases. Thereby, you must inform the security, the sheriff's department or the marshal's department who are flanking the security entrances that you cannot enter the building unless you have law enforcement escorting you within the building. Understood? You might want to carry your disposition sheet every time you enter the building so they won't have to keep looking it up. Understood?
Yes.
You are to have no further contact with Miss Soraya Ward. You're to stay 200 yards away from her and not communicate with her in any way, form, or manner. You are to, do you understand?
I didn't understand the name who you were saying, but I understand. I don't go down to the courthouse patrol, but I understand what you're saying. It won't be no problem out of me, huh?
You are to have no further contact with Soraya Ward. You're to stay 200 yards away from this person and not communicate with her in any way, form, or manner. You're to have no contact with Anel Winfrey, Juliana Peterson, Siri Patel, and Simone Hilton, who are employees at the Fulton County Courthouse.
Understood.
You are to have no further violent contact with any of these 4 prosecutors if you happen to be in a courtroom in which they are addressing any cases. Understood?
Yes.
All right, that concludes your sentence. Thank you.
And Your Honor, just so to make clear for the record and to for defendant's information here, he did plead under the First Offender Act on July 22nd, 2015 for theft by conversion, so he cannot use that again.
Understood. Oh, I forgot one other more important thing. Mr. Fambro, you are to subject yourself to an MHET, and your probation officer will explain to you what that is. That must be started within 30 days of your release at your expense, and you must subject yourself to any treatment that is recommended by the healthcare provider. Thank you.
All right.
All right, Mr. Finling, if you would like to submit the plea sheets to Ms. Champion, and then we'll be able to complete that. Deputy Francois, we have concluded with Mr. Fambro's case. Ms. Peterson, Ms. Hilton, and Ms. Winfrey, thank you very much for your time. You're excused. Thank you.
Next, position 17, Mr. Davis. Come on, Mr. Davis.
Mr. Davis will have 3 cases before us. And are you Candarius Brayon Davis?
Yes, ma'am.
All right. He is position 15, 16, and 17. Do I have conflict counsel available to represent Mr. Davis? All right, Mr. Dave, Ms. Champion, has he been appointed counsel yet?
Yes, Mr. Murphy was appointed on position number 15. So I think we need to try to get in touch with him to see if he's going to appear.
All right. Deputy Francois, we need to reach out to his attorney, Mr. Dennis Murphy, to have him come in on the Zoom. So may I address another case while we're waiting?
I got Mr. Simmons on probation counter.
All right, I'm going to go ahead and take our probation case first, and he is at a different location. All right. Give me a minute to get it. All right, Ms. Trina Harris, if I could please place you on oath. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right, thank you. Let me just get to Mr. There we go. All right, and we have Mr. Charles Edward Simmons. Is that correct?
Yes, ma'am.
Okay, Mr. Simmons, this is a probation revocation hearing involving your case. Your case number is 19 CR 007745G. With regards to this case, there's been a probation revocation petition, and you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Catrice Ellen. We are first going to hear from our probation officer, and then we will hear from your attorney. Ms. Harris, why are we seeking to revoke Mr. Simmons' probation?
Yes, Your Honor. Mr. Simmons was sentenced to probation on September the 16th, 2019. He was ordered to complete 8 weeks of anger management. Mr. Simmons failed to report to probation and provide us whether or not he enrolled into those classes. Mr. Simmons has 7 months and 28 days left of probation. Probation recommendations was to actually continue him on probation and to enroll into those classes within 30 days upon his release.
And how many weeks anger management was he to complete?
8 weeks.
8 weeks. And you have no record that he's completed any of the classes, correct?
Your Honor.
All right, thank you, Ms. Harris. Ms. Helen?
Yes, Your Honor. When I went down and spoke to Mr. Simmons, he was not aware of a few things. Number one, where to report what things to be doing on probation. He does suffer a current disability that he's the only person helping himself with, which also made it hard to report, Judge. But when I spoke to him, I did mention that probation was going to continue him on his probation. I have an up-to-date address. I also have an up-to-date phone number, Judge. And so Mr. Simmons basically just didn't have enough gusto to with the disability to report to probation. But when I went and spoke to him, he understands the seriousness of this case, reporting to probation. He understands that, again, probation would like to continue him with the enrollment of these classes.
All right. And is his current address still at Faith Cole Street?
Let me update that with the court now, Judge. It is 2045 Faith Cole Street, 30334 College Park, Georgia.
I'm sorry, did you say 2045?
Yes, Your Honor.
Faith Cole Street in College Park.
Correct, Judge.
All right. I'm going to accept the state's recommendation. And he is to continue on probation for 7 months and 28 days, which means he has about 8 months left on probation. He's going to report to probation every month. I'm going to waive his probation fees for the first 4 months. And Mr. Simmons, I was the one who signed your plea sheet back in 2019. And it was very, very clear that you were to complete 8 weeks of anger management classes, which you have not done so. Within 30 days of being released, which means that by your second visit to your probation officer, you must show proof that you have started your anger management classes. Your first probation visit will be next Tuesday at 132 Mitchell Street in Atlanta, Georgia. Repeat that address to me.
Your Honor, he also has a hold, so he won't be able to report next week. But once he is released from that hold, he will be reporting, Your Honor. His address is 2045 Faith Cole Street, College Park, Georgia, 30334.
Okay. So we'll need to amend his address on Odyssey. So once he's released from the other hold, that's when his probation will begin. That's when the 7 months and 28 days will begin. So within 48 hours of being released, he's to report to probation at 132 Mitchell Street. Did you hear that, Mr. Simmons?
Yes, Your Honor.
What's that address again?
I think it's at 130 Mitchell Street. I know the building downtown. I don't know if I got the address right. But I know the building.
If you know the building, then you have no excuse for not reporting to probation.
Yes.
By your second probation visit, you must show proof that you have started your anger management classes. Otherwise, we can just finish out the rest of your sentence at the Fulton County Jail.
Yes, Your Honor.
All right, that concludes this probation revocation hearing.
All right, that add on 2 and 3, Mr. Ferguson.
All right, we have Mr. Keith Ferguson, case numbers 21 CR 0062999Y, and case in which he's been charged with battery against a female who is pregnant and battery family violence from June 1st, 2021. And the second case is 21 CR 00630Y, in which he's got a battery family violence from November 4th, 2021. Mr. Ferguson, you have a right to remain silent. Anything you say about these cases, your statements can and will be used against you. You have a right to an attorney, and representing you is Miss Helen? Mr. Finley or Miss Helen, who's representing him?
I'm sorry, Judge.
Mr. Finley? Okay.
So sorry, I didn't hear.
This is add-on positions 2 and 3, Mr. Keith Ferguson.
Yes, Judge, that is my case.
All right. I understand that these cases are going to be arraigned, and you want to address bond. Is that correct? Oh, just arraignment.
Just arraigned, Judge.
Just arraignment. Okay. So, Mr. Ferguson, I understand that you plan to enter a plea of not guilty to both these cases, and that you would like a trial in this matter. You've been advised of your right to remain silent. Anything you say about the facts, your statements can and will be used against you. Is that something you need to ask the court or your attorney?
Yeah, I was, it's supposed to be 3 cases.
He does have an additional case that's open. It's just not on the calendar for today.
Okay.
Right. Does anyone have that particular case number? I mean, Mr. Finling, are we entering a plea?
Sorry, go ahead, Judge.
Are we entering a plea on that case are we entering a not guilty plea on that case as well?
If we could, that would be.
Let me see if somebody has the case number. I only have these two right now.
It's 20 CR 001 778Y. Battery family violence.
From what date?
2/27/2020.
All right, yes, that's an open case, battery family violence from a February 27, 2020 incident. All right, and Mr. Ferguson, are you taking a not guilty plea in all these three cases?
Well,
all right. Ms. Champion, we're going to have to arraign all these three cases. Would you be able to do so with all three?
Yes, ma'am.
All right. So with regards to all three cases, you've been advised of your right to remain silent, and your attorney is Mr. Finling. Mr. Finling, are you ready to proceed in even the third case?
Yes, Your Honor.
All right. So with regards to all three cases, Mr. Finling, do you waive a reading of the accusations?
I do.
Mr. Ferguson, as you have already informed us, you have three open cases against you, all involving battery domestic violence charges. Upon your entry of a not guilty plea to all the charges in these three cases, the cases will then be scheduled for trial before the division judge, which would be Judge Fred Eady. You are presumed innocent, legally presumed innocent of these charges, and upon your entry of a not guilty plea, the case will be scheduled for trial, where the prosecutor would have the complete burden to prove all the charges against you beyond a reasonable doubt. If the prosecution succeeds, you could be convicted of one or more of these charges in all three cases, and you could face a penalty of up to a year in prison and or up to $1,000 fine for each convicted offense. Given this information, how do you plead to the three cases I have listed?
guilty.
Thank you. All three cases have been arraigned and further notice for trial. That concludes these cases. Thank you.
All right, yes, we got position number 4, Mr. Awasika.
Is that on the add-on?
No.
Okay. Could you repeat the case number again, please?
Position number 4.
Mr. Awasika?
Yeah.
All right. Mr. Finling, I've got a private attorney listed for that case. Do you know who the attorney is?
Yes, he stated it's Mr. Max, and then the last name is SCHARDT. Not quite sure how to pronounce that, but I did try to call the private attorney and left a voicemail, but I did not hear back. Just to let him know that he had court today to make sure he knew.
SCHERTY.
Oh, ARDT. SCHARDT.
DT. Shardy?
Something like,
Max
yeah.
Shardy?
Yeah, Max.
Right. Mr. Awasika, is that your current attorney?
Yes, Your Honor.
All right. Mr. Max Shardy, I'm sounding out for him. Max Shardy. All right, I do not have a Max Shardy on the Zoom conference. We have reached out to Mr. Max Shardy, but he
Judge,
has.
you want me to find him?
If you know who it is, I'll give it a few
Yes.
moments. Okay, thank you.
Maxwell
Ms. Walker.
Sharp. He used to be with the Public Defender's Office.
Okay.
He's a private lawyer now. Could I just find out when he might have filed his entry of appearance? If it was recently, then probably private. If it was a long time ago, maybe the inmate needs another appointment to the PD's office.
All right, I'll give it a few moments if you want to reach out to him. All right, thank you, Rockwell.
Could you tell me who the inmate is, Judge, and the
All
case
right.
number and the charge?
Case number is 22 CR 004-237E, violation of a protective restraining order, a misdemeanor from December 27, 2021. Last name is, and I'm going to spell it, AWOSIKA. First name, OLAOLUWA. All right, Ms. Rockwell, I will hold
Yes,
while you
thank you,
attempt to
Judge.
reach. For South, do you have another person I can address?
Yes, ma'am. I got number 10 and 11, Mr. Coleman. Mr. Coleman,
Position number
10 and 11.
11. All right, this is position 10 and 11. We have Mr. Stephen Coleman. Are you Mr. Coleman?
I am, ma'am.
All right. Mr. Coleman, my name is Judge Lal, and we will be addressing 2 of your cases. Please remember you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Findling. Mr. Findling, we are still going to arraign this cases?
Yes, Judge, and I just very briefly wanted to address bond.
All right. And do you waive a reading?
I didn't hear what my attorney said.
Your attorney's name is Zach Findling. He is,
Yes.
do you see him on the screen?
Yeah, I didn't hear what he said.
Oh,
sorry.
Hey,
Mr. Findling?
Yeah, Mr. Coleman. It's me. I'm here. We are. I'm just going to make sure or ask for a signature bond on your behalf, sir.
I was already given a signature, but I don't know where it came from.
Yeah, we.
When they,
Yes, sir. So you do have a signature bond. So you have 3 misdemeanors. You added a signature bond on 1, and then a $500 surety bond on the other 2.
That's not accurate. That's not. I'm looking at.
Mr. Coleman, if you could please let me advocate on your behalf, okay?
Mr. Coleman, let me just go over the cases and then I will have you respond if you want to, okay? All right. So your attorney is Zach Findling. As I was saying, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you in this virtual recorded proceeding. Understood?
Understood, ma'am.
Your first case is 22 CR 004-250G. You have been accused of willful obstruction of a law enforcement officer and criminal trespass from a July 1st, 2022 incident. And in this particular case, your bond is a $1,000 surety bond. It is not a signature bond. It is a surety bond. And you're required to stay away from all model locations. In your second case, that is 22 CR 004-263G, you were accused of criminal trespass from a March 20th, 2021 incident. And in that particular case, the charge is criminal trespass also at, I believe, let me just make sure. Yes, it was also at a Marta location, and you were given a $1,000 signature bond through the jail. So the bond hearing will be addressing one of your cases. Do you understand?
No, I don't understand, ma'am.
You do not have a signature bond in both cases. You only have a signature bond in one case. All right. So, Mr. Findling, do you waive a reading of the accusations?
Yes, Your Honor.
All right. So, Mr. Coleman, I've read you the 2 cases and the charges and the dates. You are legally presumed innocent of these charges, and upon your entry of a not guilty plea to these charges, the case will be scheduled for trial. At the time of the trial, which will be held before Judge John Mather, the state, the prosecutor, would have the complete burden to prove the charges against you beyond a reasonable doubt. If the state succeeds, you could be convicted of one or more of the charges brought against you, and you could be sentenced to up to a year in prison and or up to $1,000 fine for each convicted offense. Given this information, how do you plead to the charges raised in both these cases?
Judge Law, Commissioner speak.
I need to first understand, how do you plead? Do you plead not guilty to the charges in both these cases?
I don't want to plead anything. I got jumped on target by an officer, man. And the judge conspired with the officer right up.
Hey, Mr. Coleman, we spoke yesterday and you stated adamantly that you wanted to plead not guilty. If you want to do that, if you could go through with that so I can address bond for you. And then secondly, please make sure you remain respectful, sir, please.
Mr. Law, Mr. Fine, I have been completely respectful, only that I've been defending myself only like I can because nobody else knows what happened. And
I understand. We're not going to address those facts though right now. I want to address.
I've already been arraigned. How am I giving another arraignment today?
All right. So in that case, Mr. Coleman, if you're not ready to take a plea today, then we can reset your case after you've spoken to your attorney. But if you have anything to add, first of all, I need you to understand that if you make any statements about the facts of your cases, your statements can and will be used against you by the prosecutors who are present at this hearing.
Oh, I'm definitely innocent.
So if you want to waive your right to remain silent, you must say so.
I'm definitely innocent.
Do you want to waive your right to remain silent?
Yes, ma'am.
All right. How do you plead to the charges? Do you plead not guilty if you are definitely innocent?
I'm innocent, ma'am.
All right. So that means you're pleading not guilty. Would that be correct?
I'm innocent, ma'am.
Listen to my question. I accept your statement that you are innocent in that sense.
Yes,
So
yes,
are you pleading? So
I'm
are you pleading not guilty?
Guilty of no crime.
All right. So I will construe that as a not guilty plea, and the two cases are arraigned and further notice for trial. We will address bond in case number 22 CR 004-250G, where Mr. Coleman has a $1,000 surety bond for one count, for the both charges of willful obstruction and criminal trespass, and a stay away from all model locations. Mr. Finley?
Yes, Judge. I met with Mr. Coleman yesterday. He is a 34-year-old man, just had his birthday a few days ago. Mr. Coleman has lived an extremely difficult life up to this point. He's having a very difficult time in jail. He has some issues that would be best served outside of the four walls of his cell. He does have a hold on him, Judge, but I want these bonds to be one less thing that is holding him. He comes from very, very, very limited finances and has no one that's able to help him. So that's why, Judge, I am asking for this $1,000 surety bond to be converted to a signature bond, Judge, because although it's $50, to $75 plus tax that's holding him, if it was $5, it's safe to say that would be holding him as well. So once again, Judge, I am asking for that signature bond. I do have a social worker that's going to get him information on housing that I think will help ensure that he will be at court, Your Honor.
All right, thank you. Mr. Tucson, could you give me his, how many cycles does he have?
19 between Georgia and Mississippi.
All right, thank you. Ms. Sowry, do you have any response to the request for a bond modification?
Yes, Your Honor. The state would recommend the bond remain as set. This case actually occurred after his first case, which was when it happened at MARTA as well. And there was a reported fire, and the defendant was identified as a suspect responsible for the fire. So he did go to another MARTA location, and which he was not supposed to. He remained on the premises after being told multiple times to leave, and then he resisted arrest. Your Honor, on his GCIC, I do see a 2020 fugitive from justice out of Mississippi. So the state is concerned about his risk of reoffending, as well as his ties to the community, and whether he will return back to answer for the charges. So we are asking the bond to be remained as set. Nothing further.
All right, thank you. Anything else to add, Mr. Finley?
Apologize, I was on mute. Nothing further, Judge.
All right. Given his criminal history record, given the nature of the charges, given the fact that he has blatantly disregarded a prior bond order to stay away from all moderate locations, the $1,000 surety bond is the appropriate amount, given Mr. Coleman's very high likelihood to reoffend to similar charges. This case is arraigned and it will be scheduled for trial before Judge Mather. Thank you.
Thank you, Judge.
Are we going back to Mr. Iowa Seeker number 4?
If Mr. I haven't heard back from Ms. Rockwell.
He's on.
Is Mr. Chaudhry present?
Yes, ma'am.
Judge, he's on, and I'm still here. I'm just listening.
All right, thank you.
He's on, Mr. Shard is on.
Thank you, and thank you, Ms. Rockwell. Okay. Mr. Maxwell Chaudhry?
Judge, good morning. How are you?
Fine, thank you. Good morning. We have a client of yours. He is position 4. Can you see him on the screen? He would be.
I can.
Okay.
Well, just to clarify, I wasn't aware that he had this charge. I was hired for 2 aggravated stalkings, but they all seem to be related, so I can certainly handle this. But I don't think I've filed anything on this case. But
would you like
he has 2? Well, I mean, my question is, I'm representing my 2 aggravated stalkings, and I believe that I don't have the warrant for this, but and I defer to the state, but I believe that this may be a duplicate charge of what he's already charged in Superior Court for.
All right, let me read you the accusation, if you don't mind, and perhaps that might get into whether you want to proceed. But first of all, I just need to confirm that you are representing him in this proceeding, in the state all-purpose hearing.
That's fine. I plan to. I haven't filed an entry, but I will if
Solicitor General Keith Gamish does accuse Ola Oluga Obosika with the offense of violation of a misdemeanor violation of a protective restraining order in that honor about December 27, 2021, did knowingly and in a non-violent manner violate the terms of a temporary protective order by visiting Mary Biggs, B-I-G-G-S, at Emory University Hospital, Midtown, at 550 Peachtree Street in Northeast Atlanta, in violation of Georgia Law 16, Section 16-5-94. That is the accusation that was filed by the Solicitor General on July 1st, 2022. A bond of $3,000 surety bond was imposed at his initial appearance. This case has already been formally accused by the Solicitor General's office. Do you want to still proceed?
Well, we can proceed, Judge. What I'd ask, again, Ms. Biggs has taken out numerous charges against my client for aggravated stalking, and I believe that this is the same conduct that's he's being held for in Superior Court.
Understand. So he's got 2 Superior Court cases, 22 CP, 210296 and 295. Understood for the 2 other alleged incidents. So today is a plea and arraignment calendar, and also if you want to address bond. Do you need to consult with him before we do this, or I can reset the case to be addressed at another date? How would you like to proceed?
I would love an opportunity to speak to the prosecutor briefly. I just don't think it's appropriate to have duplicate charges in two different courts for the same conduct.
Okay.
So,
Your Honor, I would state just very briefly that there are 3 different incident dates, so they're not all
Understood.
the same.
Yeah, I've noted that.
okay.
So Mr. Shard, I understand your position coming in, at the summons of Renee Rockwell, but
Right.
just in the meantime, if you want me to reset the case, you will have an opportunity to speak to your client when you visit him at the jail, and you will have an opportunity to speak to Ms. Sowry. She can give you her contact information.
Well, Judge, we are going to plead not guilty today, but I would not like to, if he has a bond and is being held on this, as well as he's in no bond status on Superior Court charges, but if you would indulge me on an opportunity to argue bond, I would love to do that today.
Let's arraign the case first. Would you like me to arraign the case, or would you like to file a waiver of arraignment? And I can tell you to whom you direct the waiver.
We're willing to file a waiver of arraignment.
All right, please file your waiver of arraignment for this particular case. You have the case number, yes?
If you could
Sure.
give it to me one more time.
22 CR 004-237E. And if you could put your email and contact information to ASG Sowry.
Yes.
All right, she will email you a copy of the documents that should have been provided to you at initial appearance.
Thank you so much. I appreciate that.
All right, just make sure you give her your correct email in the chat to Ms. Sowry. All right. And so, Mr. Shard, Mr. Awasika, as I was saying, this is your case. You are represented by counsel, Mr. Max Shard. And Mr. Shard, when you file your waiver, also file your entry of appearance. And they will be emailed to april.champion@fultoncountyga.gov.
And just for clarification, you would like both the waiver and entry to be sent to Ms. Champion?
Correct.
Okay.
She's our litigation manager, and she will make sure it's updated on the system.
Great.
And so, Mr. Awasika, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Shard. This is going to be a bond modification hearing. Presently, Mr. Awasika was given a $3,000 surety bond on July 1st, 2022. And this was issued by Judicial Officer Regina Mincy. In addition to that, he has no further contact with Mary Biggs and was only allowed a third-party transfer for visitation of the minor child. So, before we proceed, Mr. Toussaint is our pretrial officer. Could you give us his pretrial history, please?
Sure. Last arrest was June 2021 for simple battery and robbery out of Alpharetta. 21 CP 200-931 is the case number. You got an open case in state court 21 CR 002689. Is that this case?
No.
The trespass, harassing communication, simple battery.
No, that's another one. 21 CR
002-689.
689.
Yeah, E as in Edward.
Okay.
That's trespass, harassing communications, simple battery against a person who is 65 years older or pregnant at the time of the offense. Got another open case, possession of a firearm by convicted felon, making improper U-turn, operating without lights required by law. 21 CP, they missing a number on that one, so I have to get that one. All right, let's see. Possession of a Schedule 4 conviction from 2015. I got a 2016 battery out of Rockdale. I'll put that in the chat for you. 2016 probation violation for marijuana. 2018 probation, 2018 FTA marijuana. Another 2018 probation.
That's good. Thank you. All right. Mr. Shaw, based on this history, a $3,000 surety bond was established. Do you have anything to add?
Well, Your Honor, I would just like to give you a little context to this. I'm going to call Mr. Awosika Michael. That's what he goes by. And so Michael Awosika, he's 26 years of age. He's from Decatur. He's always lived in the area. He graduated high school from South Atlanta High School, did 2 years at Georgia State, taking up psychology. He lives with his mother and his siblings. His mother is obviously very concerned about him and has brought me onto this case. He works at a family auto dealership, which is AutoNation Value, and that's local. He does have a daughter, and so he is gainfully employed. He's educated, and you've heard his history, and I understand that there are some pending charges. I would just like to point out that that the alleged victim, the complaining witness, is the mother of his child. I understand that he's not supposed to have contact with her. As an officer of the court, I have proof, and I'll be, now that I know that this case exists, I will add Ms. Sowery to the people that I'm sharing information with. It is clear to me that this young lady has initiated contact, has involved Mr. Awosika in her life, while also playing the other side, which is maintaining a protective order against him. And when she's become upset, even though she initiates contact, she goes to law enforcement and demands that he's arrested. And this is a horrible situation to be in for Mr. Awosika, especially considering he also would like to be a good father for the child that he has with this young lady. So obviously there's two sides to every story, but I can say as an officer of the court that I have definitive proof in my position that the state, both in the DA's office and the solicitor's office, have not been given the full story or accurate information about everything and the nature of any communications over this time period, and I'll be happy to share that with them. So, Your Honor, right now he's in no bond status for his felony cases, and I know that that would be an easy grounds just to keep his bond as is, but I would actually encourage the court to consider giving Mr. Awosika a signature bond on this, knowing that with the understanding that obviously if I'm able to get a low bond on the felony charges, which I plan to do or begin to endeavor to do that shortly, that I have shown that there's significantly more to this story. And what I don't want to do is address the felony charges, get him a reasonable bond, and then this bond still be in the way, and then have to come back here again. So that would be my preference, but I understand that these are allegations, and I appreciate you hearing us out, and we would ask for a signature bond.
All right, thank you. Ms. Sowery?
Yes, Your Honor. I would just like to give a little bit of the facts that we have currently regarding this case. The defendant was arrested at the hospital. He was there to visit the victim, whose name was given Mary Biggs, during the birth of their child. As we've heard from pretrial, the defendant does have a battery conviction from 2016. He has a 2018 probation violation, 2018 FTA, another 2018 probation violation. He has multiple cases involving this same victim, 2 in Superior Court and 2 here in state court. In each case, Your Honor, the defendant was given a no contact order, which he clearly has violated. So even if we were to take the position that the victim invited him over, the defendant is the one under the court order to stay away from this victim. So he has violated not only multiple court orders, but a temporary protection order as well. So Your Honor, we are asking that the bond remain as set regarding this case. He is a flight risk as well as a significant risk of reoffending and a risk to this victim / witness. So we are asking the court to keep the bond as set.
No further contact with Mary Biggs. The bond remains the same. If the aggravated stalking charges are resolved based on the alleged statements being made by the victim to be determined to be false, then I'm sure this case will have a equal resolution. By the present time, those are open pending cases in addition to this one, in addition to 3 other open cases. 2021 has not been a good year for Mr. Awosika, and I'm not certain what is the nature of these alleged falsities that Mr. Shad has referenced. So, Mr. Shad, I'm so sorry, but he has numerous cases, and as Ms. Sari said, involving the same victim, and the underlying bases have to be resolved before we can proceed. $3,000 surety.
Your Honor.
Yes.
Could I just ask one question? Because Solicitor Sari did reference a 4th case, and I want to make sure that I get that information.
Let me identify that. I don't know if you have this one.
I don't.
21 CR 002689E. That's a 689E, and that has got attorney Bill Kitchens as his defense attorney of record.
Okay. All right. Okay.
All right. Thank you.
All right. Thank you.
Okay. Thank you. That concludes Mr. Awasuka's case. His case has been arraigned and further notice for trial.
Thank you.
All right, next guy number 34, Mr. Wick.
Okay.
All right, Judge, next we have position 18, Mr. Donaldson.
All right, Mr. Donaldson will be on deck, and I'm just addressing Daween Wick, position 34. I'll be right with you, Deputy Francois. 22 CR 000946A. Mr. Wick has got 2 counts of cruelty to animals, and this is from a December 4th, 2020 incident. Mr. Wicks, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Catrice Helen. Ms. Helen, do you still need a breakout room or?
Yes, Your Honor, for position 34.
All right. Ms. Champion, if you could place Ms. Tortorello, myself, and Ms. Helen in a breakout, please.
If I could be included, Your Honor, please.
Yes, and Mr. Walker too, please.
Thank you.
Me as well, Judge.
All right, Mr. Howard too. All right, 4 South.
Yes, ma'am.
Ms. Catrice Helen will need to call and speak to her client, Mr. Wick. Could we do that while I address courtroom 2?
Sure, to put a number in the chat.
All right, or we can place 4 South and Catrice Helen in a breakout room. Ms. Helen?
Yes,
Are you
Your Honor.
okay with a breakout with 4 South? April?
Yes, Judge.
Ms. Champion, if you could place 4 South and Catrice Helen in a breakout room, please. And I'm going to
Yes, ma'am.
address courtroom 2. Courtroom, Francois, who did you say is that position 9?
No, Judge, this is gonna be position 18, Mr. Donaldson.
18, okay, sorry, thank you. Willie West Donaldson, is that correct, sir? Courtroom 2, is that Willie Donaldson?
Yes, ma'am.
All right, case number 20 CR 002682E. Mr. Donaldson was accused of DUI per se, DUI under the influence of alcohol, less safe, and improper stopping from November 23rd, 2018. Yeah, all right. So, Mr. Donaldson, you have been advised of your right to an attorney, right to be silent. And do you have a private attorney? Is that Ms. Rockwell?
Yes, Judge.
Okay. So, Ms. Rockwell, how will we be proceeding in this case today?
Judge, would the state be ready? I mean, I know the state's always ready. Doesn't take long to have a little bond hearing. I filed an entry. I emailed it to you and to Mr. Miss Sorry, maybe I emailed it to Michael Jordan. I heard Miss Champion's name very quickly, but I didn't write down her proper email address.
April.
Would the state be ready for me to ask? April, okay.
What did you want to ask the
Would the state
state?
be ready for me? Would the state be ready for me to address bond on this? He has a $5,000 cash bond.
Yes, the
Would
state.
the
is
state be
prepared.
ready for me to? Okay. Judge, for the record, he is 49 years of age. Today's his birthday. And he was born in Valdosta, went to Valdosta High, graduated. He does have 5 children, and he is a foreman for Metro Waterproofing. He's been there since 2011. He just can't make a $5,000 bond cash. I don't know if I could make one of those if I was in jail. Maybe I'd have some friends that would have a little bake sale and come and get me. But would the state be upset about making this a regular bond and surety bond instead of a? We all kind of lost touch during COVID, and he's, anybody that's had a job since 2011,
Let me ask his correct address. We have Glen Street, apartment 252. Is that correct?
And I'm sorry, Judge, I'm not in an airport. I'm just in a parking lot under an airstrip. So the planes are flying over. Can I ask his wife real quick? Can you give me his correct address, ma'am?
I have a Nadia Robbins who is driving, and we're going to remove her from the Zoom until she
Can you give me his correct address,
So I
please?
cannot, Miss Champion,
The
please?
address is 490 Glen Street Southwest, Atlanta, Georgia, 30312, apartment 252.
252. Judge, are you ready for the address?
Mr. Donaldson seems to be waving his hand. Do you have a current address, Mr. Donaldson?
Yes, ma'am. I talked to Mr. Finley yesterday. They have a plea offer today. And they said they put one in the plea offer.
And I didn't want you to just take the plea. Like, Judge, how about if I have can I get a breakout with him real quick, just in the event?
You will have to call him at the jail, 404.
I just want to take the plea. I just want to take the plea. I mean, all that.
All right.
I want to take the plea. I talked to Mr. Fine, he said he brought the plea yesterday. I told him I had an attorney, and I'm fine with the plea they got the offer yesterday. And so I don't want to be worried about getting no bond. I don't have no money to be trying to make no bond, period. Now I want to just take the plea and get out of the way.
Ms. Rockwell, do you want to address the possible plea?
I will address all that with him and with Madam Prosecutor and get the exact offer and a possible affidavit of the first conviction. But can I just have that direct line for the phone call?
All right. Francois, Ms. Rockwell will call the jail and speak to Mr. Donaldson.
Could I get that number, please?
404-612-2312.
You don't want to. Okay, perfect. May I be excused, Judge?
Oh, yeah, you're coming back in, right? Okay.
Yes.
Mr. Murphy, good morning.
Good morning, Judge.
All right, Mr. Murphy, you represent Kendarius Davis.
That's correct, Judge.
All right, he has 3 open cases, and we have Mr. Davis in the courtroom. Can you see him?
He's right here, Judge.
All right, could you please tell that gentleman to keep it down? He's not the only person in the courtroom. All right. So, Mr. Murphy, I was made aware that you only thought you represented him in 1 case, but he has 2 other cases.
Yes, and he had bond. I represent him on a 20 CR case, and he has two 21 CR cases for which the state was able to get the bond revoked, and there's a $5,000 surety bond on both of those 21 CR cases. I'm not sure I believe bond was revoked on my case, the 20 CR case.
Oh, yes, that's correct. So today, would you like to arraign those cases and perhaps reset them for a possible plea?
Judge, next week, I'm actually, as of Friday, I'm on leave for about 11 days, Judge.
All right.
I just wanted to address I spoke to Mr. Jordan. I wanted to address the issue of bond in terms of these cases.
All right. So we will address the bond after I've arraigned the cases. So do you waive a reading of the accusation?
Yes, Judge.
All right. Thank you. Mr. Kendarius Davis, you have 3 open cases before the court. Position 15 is 20 CR 004-017Y, in which you are accused of simple battery domestic violence from October 24th, 2018. The second case is 21 CR 005-026Y, in which you are accused of criminal trespass from January 25th, 2020. The third case is the charge 21 CR 005-048Y, in which you are accused of simple battery against a person who is 65 years or older, or who is pregnant at the time of the offense. And that alleged incident date is November 21st, 2019. I've already advised you that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is Mr. Dennis Murphy. Mr. Davis, do you want to waive your right to remain silent and say something? Because I wouldn't recommend it.
Mr. Davis, I would remain silent given the circumstances. There'd be the problems would far outweigh any benefits. So I would ask you to remain silent.
All right.
I'm sorry, Rose. I just heard the last count that you said I assaulted somebody 65 years old. No,
the charge is simple battery against a person who is 65 years or older, or who is pregnant at the time of the offense. That's the charge. Okay.
And I never had a chance to prove what I had, my evidence in court, because Mr. Murphy told me to be silent.
Understood. And he's absolutely right. You will have opportunity when the case goes to trial. But right now, please remember that you have no burden to prove anything. The only party that has to prove the case against you is the prosecutor. They have to prove the charges against you beyond a reasonable doubt. You have a right to remain silent. You have a right to an attorney, and you have a right to not have to prove anything. Understood?
Yes, ma'am.
Okay. So right now on Mr. Kendarius's charges, he has a total of $18,000 bond on all the charges that he has right now. So Mr. Murphy, would you like to proceed?
Yes, Judge. So Judge, are you saying that on the 20 CR case, he has an $8,000 good bond?
On the 21 CR case, simple battery against an elder person or pregnant, it's a $4,500 cash bond. On the criminal trespass, the 21 CR case ending in 5026Y, he has a $4,500, it looks like a cash bond as well. And it says cash bond or surety bond.
Judge, on the 221 CR cases, there's surety, $5,000 surety bonds on both of them, not cash. And that's for 21 CR ending in 5026
you're right.
and
You're right.
5048.
You're right. You're right. You're right. I was reading a different column. That was probably his prior bonds. Yeah. $5,000 surety bond. And then on the simple battery domestic violence from 2018, his bond is $3,500. And then he's got two other, he's got a $4,500 bond from a Superior Court matter.
Okay, all right. So that's, okay, I was thinking that the 18,000 was total for all three cases, and you're saying there's one in Superior Court.
Yeah, this 18,000 based on all the cases he has right now.
Okay, all right. So there's 4,500 cash on the 20 CR case, and then there's surety bonds in the other two cases. Okay.
No, it's 5,000 surety bond, as you said.
Yes. Judge, on the 20 CR case, as I wanted to address the issue of bond, my client could not make the bond for which got revoked because the state alleged that that he was having contact with the alleged victim, and there was a hearing that Judge Edius was of the opinion or made a decision that the fact that my client lived 3 or 4 houses away on the same street, he made a decision that that was contact. It's my understanding that my client moved away from there as he was required to, but for economic reasons, he could not make any of these surety bonds. And that's why the case pretty much stopped. And now he's in front of you. And I have no reason to believe that that his economics has changed. I'd like the court to consider a reasonable bond under the circumstances. I know he had maintained employment, but he simply did not have, which would have required almost through a bonding company, at least 1,000 on the 21 CR cases, then plus the 4,500 cash bond. So essentially, they were asking for $5,000 to get him out, and he simply does not have the money. I spoke with him numerous times. There was no family or anyone who could, or an employer that could assist him. And at this point, it amounts to no bond. And I believe my client did relocate and does not live on the same street as this alleged victim. So I'd ask the court to consider a reasonable bond in the circumstances.
All right. Mr. Tucson, any priors? Any open cases actually, other than the 3 I've just listed?
Other than those, no. However, he has a 2021 Rockdale battery DV, cruelty in the first, carrying a weapon without a valid license conviction.
That was a conviction?
Yes. So September 2021 was the date. So he got 12 months for each, but it's they all consecutive to count one.
Right. This was in Rockdale County.
Yes.
Right, thank you. Ms. Sari?
Yes, Your Honor. Respectfully, the state is asking for the bond to remain as set, and if bond is an issue, there was I'm sorry, I can barely hear.
Courtroom 2, please chime it down. Thank you. Ms. Sari, go ahead.
Yes, Your Honor. Judge Edie has already heard the motion. So this has been argued before the division judge, and we're asking the court to respect that order that was granted. Evidence was presented, and Judge Edie did consider everything before giving his ruling. So we are asking the court to keep the bond as set. And not only was the bond for this case revoked, but the other two as well. So we would ask the court to consider that as well when you're making your ruling.
All right. So I noted that the 20 CR case, there's been a waiver of arraignment. All the other cases have been arraigned. And given the nature of the charges, the numerosity of the charges just in the last couple of years, as well as this recent conviction in Rockdale County, the request for a bond modification is denied. All right, Mr. Murphy, all 3 cases will be further notice for trial before Judge Edie's jury trial calendar or bench trial.
Thank you for your time, Your Honor. Thank you for hearing it.
Thank you.
Mr. Davis, I'll be in touch with your girlfriend. Thank you, Judge.
Just 1 second. Courtroom 2. Yes, Mr. Davis. Courtroom 2.
The only reason why they saying I had contact with the.
That is not what I am.
Mr.
That
Davis.
is not what I'm addressing. That is not what I'm addressing.
Mr. Davis, I already mentioned that to the judge, what the finding was. There's no good of you saying anything else. It's basically a redundancy.
I have a child on that street too, and I also have evidence about I never had contact with
Mr. Davis will address that at the trial. It does us no good at this point. Thank you, Your Honor, if we can conclude.
Yes, we have concluded. Thank you. Thank you, Francois.
Going back to number 34, Mr. Wick.
Yes, Judge, this is going to be a not guilty plea, bond hearing and arraignment.
This is position 34.
Correct, Judge.
All right, we had just addressed Devin Wick. I've already advised him of his case, his rights, and the charges. And do you waive a reading of the accusation?
I do, Judge.
All right. Mr. Wick, you are at 4 South. Could you please acknowledge by saying yes?
Yes.
All right, thank you. Mr. Wick, you've been accused of the 2 misdemeanor charges, and upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the prosecution would have the burden to prove the charges against you beyond a reasonable doubt. If the state succeeds, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine for each convicted offense. Given this information, how do you plead?
No.
Not guilty.
Not guilty.
This case has been arraigned and it's going to be further notice for trial. Anything else, Ms. Helen?
Yes, Your Honor, we are requesting a bond hearing for this case.
All right, go ahead.
So Mr. Wick is 22 years old. Currently, prior to being incarcerated, he was working for the State Farm Arena since 2018. He did have an interview for another package supply job prior to this arrest about having been confined for 10 days. So he did have, he's employable. He did have an opportunity for employment. He is a proud father of 2 children, Judge. Currently, he has a partner who is pregnant and has a child on the way, a 2-year-old daughter. And Judge, we are asking for a signature bond. Mr. Wick is here for a failure to appear from June 8th, 2022 in Odyssey. There is record of a 94 Chapel Hill, or at least Chapel Road address. He no longer resides there. I have an up-to-date address that he's been at since the last year of 2637 Old Hateville Road, Southwest, apartment 40E, Atlanta, Georgia, 30315 as an updated contact address. I do also have an updated number for the court as well to be able to contact Mr. Wick, because again, this is not him wanting to not appear. They moved and he did not update the court. I have spoken to him and he understands that if any changes like that are made, the court must be notified of that so that he can get all of his court notices. But to go to the Ayala factors, Judge, he will appear to his court dates. I have up-to-date contact and mailing address for him. I do not believe he's a danger to the community. I would also like pretrial services to read his history.
Can I confirm that he has an open felony case from July 5th, 2022?
Yes.
All right, that's all I need to know. Thank
Want
you.
the case number?
Yeah, if you have it.
22 CP 210428.
Thank you. And there's a $1,500 surety bond in that case presently.
Yes, Judge. I also see that, yes, that's a felony hold from July 5th. So, Judge, for this case, there is no bond. I do believe because of that FTA, we are requesting that signature bond of no more than $1,500, $1,000 for the first cruelty, $500 for the second one. And again, Judge, if you feel that he's ineligible for that signature bond, we're asking for a surety bond of no more than $1,500 be set for this case.
Understood. Thank you. Ms. Sari? Oh, Ms. Tortorella?
Yes, Your Honor. Does this defendant have a criminal history other than that felony?
I'm just interested in the open case. That's all. I've got the FTA. I've got the arrest on the day. Hence, the FTA warrant was executed when he was arrested for the felony case.
I'm just asking because.
Oh, I'm sorry. Okay. Yes. Toussaint, do you have any priors?
I got 3 total. 2018 trespass, July 5th, 2022, the possession of a Schedule 1, misdemeanor possession of marijuana, and the third cycle is this FTA for cruelty to animals. That's it.
Which will be this one.
Correct. You don't have any out of state or anything.
All right, thank you. So there is no bond on this in this case. On the date of the offense, he only got a citation. I believe it was during COVID time, so he just got a citation. And he FTA'd and he's back in jail because of that felony. We're asking for that for the first cruelty to animals charge, a $3,500 surety bond. For the second count, same amount, which would be a total of $5,000 in surety. In this case, Your Honor, on December 4th, 2020, Officer Painter of the Fulton County Animal Services arrived at 94 Chappelle Road Northwest in Atlanta, and he could hear a puppy whining. The officer walked up to the front porch and observed a blanket over a crate and smelled a very strong odor of urine and feces. The officer pulled back the blanket and saw a small brindle Chihuahua mix, female dog that was very malnourished. The officer advised the puppy was standing over a very nasty and soaked rug or blanket and had no water. The officer then banged on the owner's front door, and the owner, later identified as defendant Divine Wick, came right out. The officer asked the defendant if that was his dog, and he responded that it was. The officer asked how long had the dog been in the crate. The defendant responded the dog had been inside the crate a week or two and that he had forgotten about it. The officer flipped the blanket farther behind the cage and observed a second puppy hiding behind the cage. The officer asked the defendant if the second puppy was his also, and the defendant advised that it was not and that it was a stray. The officer confiscated both dogs and wrote defendant a citation for animal cruelty that day, and he let him sign the dog over. The defendant was eventually arrested for this later on, and these events did occur in Fulton County, Georgia. Your Honor, we are concerned about not only his risk of reoffending and Yes, just the risk of reoffending and the fact that he could potentially, again, not only reoffend or violate any laws, but commit felonies while he's out on bond. He has that open felony case, June 5th, 2022, and he's a potential flight risk, Your Honor. He recently FDA on this very old case, which not very old, but it's rather old. It occurred in 2020, still open. So for that reason, we are asking for the $5,500 surety bond with conditions that he cannot own and have no contact with animals, no drug or alcohol, no weapons, and no new violations of Georgia law. Nothing further from the state.
Ms. Helen, anything else to add?
Just that the $5,500 bond will be a no bond for Mr. Wick. He cannot afford that. Again, I do not think he's a danger to the community or reoffending towards any other animals or any other possible animals mentioned, Judge. So that's why we're asking for that signature bond.
All right, so his original address was at Chappelle Road, and he failed to appear, and he failed to update the court with his new address so that we would not have had a failure to appear on the record. So that, unfortunately, is on Mr. Wick. With regards to the bench warrant that was issued against him, that was just court procedure when he doesn't appear in court. And that warrant would never have been executed unless Mr. Wick had been arrested on what is now his outstanding felony charge. Given the nature of the charges, the allegations, I'm going to set the bond at $350 on each count. And his total bond for this case is $700 surety bond. He is not permitted to have any pets at home, domestic pets, or commonly referred to as exotic pets, nor is he allowed to own any pets at any other location. Mr. Wick, do you understand the court's order?
Yes, ma'am.
Thank you.
Can I say? Oh.
No, Mr. Wick, I advise you not to say or make any other statements.
If you change your address, you make sure that you first entity that you notify is the court, because we will be sending you notices to appear in court. Any future failures to appear will result in your bond being revoked again. Thank you.
Thank you, Your Honor.
Your Honor, will you add no weapons and no drugs or alcohol? He's out of bond.
Not for these particular charges. We'll be addressing that shortly. Okay. Courtroom 2, who do you have, please?
Position 4, Varner.
Would that be on the add-on calendar?
That's a position 5, Judge, and then he is on the add-on
Oh,
calendar.
I'm sorry, position 5. I have 4 written.
Okay, that's okay. Position 5, and he's on the add-on in which case?
That's correct, Judge. He's add-on number 1.
Number 1, okay. We have State versus Dwayne Lamar Barner. Are you Mr. Barner?
Yes, ma'am. Yes, Your Honor.
Thank you. First case we have is position 5 on the regular SAP, and that's 22 CR 0000269J, in which Mr. Barner has been accused of criminal trespass and damage to property from September 1st, 2021. He has an additional case, 21 CR 001-600J, in which he was accused of simple battery from December 9, 2020. With regards to both cases, I understand this is going to be a negotiated plea. So Mr. Barner, if you could please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. All right. Ms. Sauri, what's the global offer for both cases?
Your Honor, I am handling position 5, and then ASG Tortorella will be handling the add-on position. For the criminal trespass and damage to property, date of offense 9/1/2021, the recommendation is 12 months to serve, 354 days. Credit for time served, 177 days. The balance probated, a 12-week anger management course, and stay away from the Buckhead Library. That's at 269 Buckhead Avenue in Atlanta.
All right, thank you. Ms. Tortorella, what's the state's recommendation for add-on position 1?
Yes, Your Honor, the state's recommendation, give me a moment, is for position 1, it's 21 CR 001600J.
Yes. It looks like it's a time served and stay away from incident location.
It's 12 months, served 365 days, credit for time served 238 days, balance suspended, no contact with the victim, stay away from the incident location, Your Honor. That's what we offered the public.
All right. Thank you. And Mr. Finling, what is your?
Yes, Judge. That is our understanding of each offer, of which we do agree, and additionally stipulate the factual basis, ID, and venue, Judge.
And to add, Your Honor, both cases will be, I believe they're concurrent.
Yeah. And the second one was stay away from MARTA. Do you have any objection to stay away from MARTA in accordance with any suspension? I think that was the add-on 600J.
Was it just that one, stay away from that one station, or was it just abide by the?
It just said MARTA on the bond order, so that's why I'm trying to clarify.
If it could be just that one station, obviously if he does have a suspension, then stay away, but
I'm going to make it stay away in accordance with any suspension.
Okay, yes, that's fair, Judge. Thank you.
All right. And do you stipulate to the factual basis, venue, and ID for both cases?
Yes, Your Honor.
All right. Mr. Barner, please unmute.
Sorry about that, Judge.
Excellent, thank you. Mr. Barner, have you consumed any kind of medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far for both your cases?
Yes, Your Honor.
And are you satisfied with your attorney, Mr. Finling?
Yes, Your Honor.
And if you decide to take the pleas in both cases, you would have to waive your constitutional right, that is, give up your constitutional right to have a trial in a court of law, to have the ability to have your attorney assist you so that you can confront your accuser, examine witnesses, challenge the state's evidence, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to one count of, criminal trespass and damage to property from September 1st, 2021?
Guilty.
Your sentence is time served. And Ms. Sowry, he won't have enough time to complete 12 weeks of anger management with the remaining time left on his sentence. You're asking to serve 354 days.
If I could, I'll chime in. That was an error on my end. Obviously, the math is not mathing, so we're just going to make a time serve offer to your point.
All right.
Thank you.
It's going to be a time serve offer. You do not have to be on probation. Your jail time for this case is concluded. You just have to stay away from the Buckhead Library at 269 Buckhead Avenue in Atlanta, Georgia. If you return to that location, you will be arrested and charged with criminal trespass. Do you understand, sir?
Yes, Your Honor.
Okay. In your second case, it's also a time-served plea, and you are required to stay away from all MARTA property in accordance with any suspension they may have that is still active. So you would have to contact MARTA via the phone or email and find out if they have any suspensions under your name.
Yes, Your Honor.
All right. That concludes the cases. Thank you.
Next, we have position 3, Mr. Yerby.
All right. Repeat the name again, Francois,
Mr. Yerby, position 3, first name is Johnny Lee.
I think that must be the, I think that's competency.
Okay,
Actually, that's on the probation.
I think that's the add-on.
That's the probation revocation.
probation revocation. Okay, thank you. Sorry, Francois is doing a better job of handling all the 3 calendars. Okay. We have position number 3, Mr. Johnny Lee Yerby, and this is a probation revocation hearing for case number 19 CR 005356B. We have Ms. Trina Harris has already been sworn. She's our probation officer. Mr. Yerby, you've been advised of your right to remain silent, and your attorney is going to be Mr. Zach Findling.
Oh,
Right.
Your Honor, I have position.
Oh, I'm sorry. Okay, no problem. Your attorney is going to be Ms. Helen. So with regards to this case, Mr. Yerby, we are first going to hear from the probation officer, then we will hear from your attorney. Ms. Harris?
Mr. Yerby was sentenced to probation October 26, 2021. He was instructed to do 40 hours of community service and complete the 12 weeks anger management. Mr. Yerby has never reported to our office, have not provided proof of those anger management classes, no community service. He also had a probation revocation hearing with Judge Porter on May the 25th, 2022. That's why this warrant was issued. Probation recommendation is to continue on probation. He has 4 months and 14 days left on his case.
All right. Ms. Helen?
Yes, Your Honor. When I went down and spoke to Mr. Yerby, he's 73 years old, and last year, 2021, around February, he sustained a massive injury to his hip. He broke it in 2021. That made getting to court, getting to anything pretty impossible. However, I did speak to Mr. Yerby. He was supposed to inform the court of anything that would prevent him from coming to court or getting his notices. When I spoke to him, I do have an address of a 783 Magnolia Way, Northwest, apartment 1310 30314, to which he has been at since the last year, Judge. And so I also have a working phone number for him as well. I also have a secondary address for Mr. Yerby, a 181 Foggy, Foggy, Creek, Creek Lane, Hiram, Georgia, HIRAMGA, or excuse me, Georgia, 30314.
Which address does he check mail?
Your Honor, I believe he checks mail at the 181 Foggy Creek Lane.
In Hiram? The Magnolia Way one was the first address you gave us.
I apologize, Judge. That's the mailing address that they have on file, the updated. So he doesn't check mail at the Hiram. He was checking it at the Magnolia Way.
Okay, so that's the address we have on the system right now. Okay. All right, and what about his ability to complete his anger management and his community service?
When I spoke to Mr. Yerby, he is willing to complete the conditions. He's willing to complete the conditions and be continued on probation, Your Honor.
We're going to mark this as a probation violation. He had not appeared at the last probation hearing that was held before Judge Porter, and that's going to be held against him, as well as his failure to complete his community service and his anger management programs. I could have just as easily not accept the the probation officer's recommendation and have Mr. Yerby complete the rest of the time in jail, and he will be given 2 for 1. But I will give him the benefit of doubt. He must complete the 40 hours of voluntary community service hours, and he may do that at any nonprofit agency, which is not a school and not a church. Understood?
Yes, ma'am.
This is 40 hours, and this has got to be basically voluntary community service.
Yes, ma'am.
You must also enroll in a 12-week anger management program, which you must complete before the end of your probation.
Yes, ma'am.
You must enroll in those classes within 60 days of being released.
Yes, ma'am.
That means by your third probation visit, you must confirm that you are enrolled and attending anger management classes and show proof of those classes. And you must show proof that you have also started on your community service hours. You must report to probation every month in person. I will waive your probation fees. But if you fail to complete any of those requirements, or if you fail to enroll, then probation has a right to revoke your probation again. And next time you will complete the rest of your time at the Fulton County Jail.
Yes, ma'am.
Thank you.
Thank you.
Thank you,
Next,
Judge.
we have position 18, Mr. Donaldson.
All right, this is Willie West Donaldson, and we're going to resume with Ms. Rockwell. Ms. Rockwell, are we going to take the plea?
Judge, he would really love to address the court on this bench warrant. If the state is ready, I was able to speak with his wife also. Could I ask Madam Clerk or Mr. Clerk what address the notice was sent to? I can give you his updated address. And there looks to be a document in the file where they went and even filed an updated address in a file with the number of apartment 252.
On January 18, 2022, we had a return from a 490 Glen Street, Southwest Apartment 352, Atlanta, Georgia.
Right, that's a one digit off, Judge. Their apartment is 252. I don't know how that happened, but I'm looking at.
That's what we have. Oh, it's 352, okay?
Right, but the apartment is actually 252, Judge.
Okay, just one.
I just hate for somebody to take a.
His first one was sent to 1965 Cannon Court, where he failed to appear in court. There was an arrest warrant on February 5th, 2021. He made bond. And then this was the second time. So I'm not certain what address and when was updated. So Ms. Rockwell, I've got two FPAs for this person.
Okay. Could I can't see the date on this, but his wife, and I'm sorry, Judge, you can't see me because I'm scrolling right now, but I'm going to send this to Your Honor and to the, this is what his wife had in her records and to ASG Ms. Sari. And this was an address update. And it does say apartment 252 on the update, and the date that I see on it is January 31st of 2022.
Yeah. And that's what we have right now. I don't know when that was updated, but the notice was sent to apartment 352.
Okay, but I'm looking at what he filed, Judge, on January 31st. I just sent it to your email and to ASG Sari's email. It clearly shows apartment 252, and it's amazing. My neighbor won't give me my mail if it goes to her house. Right. I'm gonna have to give her a ham this coming Thanksgiving or a turkey or something so she can just hand me my mail. My neighbors sometimes are very complicated.
Ms. Sari, what response do you have to motion to set aside the arrest warrant and the bond forfeiture?
Your Honor, as you've stated, there are 2 FTAs here. And from what I can see, the defendant made bond and then he failed to appear again. So it was his responsibility to update the court or make sure they had the correct address when he received the first FTA. So
we had the correct address, but it looks like the envelope was sent with the wrong apartment number, 352.
Okay. Let's see.
Madam Prosecutor, if you could just check your email. I was looking at it. It does say 252. I don't know where it was sent, but it does say 252. I'm just getting from the court that it was sent to 352.
So that's.
And Your Honor, not to add confusion here, but am I the only one that's saying that the arrest warrant was already voided? That's what I'm confused about. On 131-22.
Well, yeah, and it looks like January 31st, 2022, the bond forfeiture was set aside. So
And I see an arrest warrant voided, so is he being held on something else? I'm not.
I'm not certain.
I just saw that the arrest warrant was voided, so I'm not sure why. If it was already voided, I'm not. That's what's not making sense to me.
Because the bond was not changed. After the arrest and after those arrest warrant and bond forfeitures were set aside, the bond amounts were not changed. So he still has a $5,000 cash bond on the DUI charges, and then he's got a surety bond on the felony charges.
Right.
Just keep it simple on our end. There's no objection to reinstate the original bond on our case.
Okay. So since the bond amount, since the bond and the arrest for bond forfeiture and arrest warrant was set aside, I'm going to reinstate his bond as it was previously issued through the bonding company back on July 30th, 2021. So now the only bond amount, and Ms. Rockwell, you can send me a proposed order.
Okay. Just tell me what that needs to look like, Judge.
All right. It just says that order to modify bond status.
The bond is hereby modified, or is it hereby?
No, it's just say pursuant to the arrest warrant and the bond forfeiture being set aside. Mr. Donaldson's bond status will be reinstated as it was back on July 30th, 2021, where he had already made bond through the Alpha Bonding Company.
Okay.
All right.
I don't guess I could get you to just give him a signature bond. Can I, Judge?
Any objection, Mr. Walker?
Yes, Your Honor.
He has been in jail. Okay.
Yes, Your Honor.
He has been in jail for a long time.
He's already got his open felony bonds. So he's got another pan to fry.
We're splitting hairs because he has no bonds. He has foreign county holds. He has felony cases. So with all due respect, I mean.
All right. Ms. Rockwell, is there anything else you want to address on bonds for Mr. Donaldson?
Just, I don't think Your Honor can touch the felony bonds.
Absolutely.
He's gonna, they surrendered those bonds, so he's not doing dead time, meaning sitting in jail for the DUI and not getting credit for those felony bonds. He's gonna make those bonds again. And then he's got to go to South Georgia. I'd rather him go to South Georgia on a case that's 19 years old. I'd rather him go with no conviction.
I agree,
So,
but the only court that can establish a release bond on the felony charges is a superior judge, and I'm not sitting as one right now.
okay, no, I know that, but would the court consider setting a bond a signature bond on him or setting a bond in the amount of something like
There is nothing holding him. As
25
soon as I sign your order, those bonds are
okay,
non-existent. because
reinstated.
we Reinstated
Okay.
retroactive to July 30th, 2021.
Okay, can I email it to you and to
Oh,
Miss
yeah.
Sari?
You can email
Okay.
it to me and to April Champion.
Okay, and I'll include Miss Sari also.
All right.
Thank you so much.
Okay.
All right, Judge.
This
Good to see you.
particular
Thank you so
case-
much.
No problem. This particular case has not been arraigned. Do you have any objection to filing a waiver arraignment at the same time?
I'll file it, Judge. I told my my paralegal, she didn't have to file one because the case was so progressed, but I'll file one.
Okay, so go ahead and file the waiver of arraignment and we will further notice this to trial.
Thank you so much, Judge.
All right, no problem. Thank you, Ms. Rockwell.
Yeah, be excused.
Yes.
Have a
thank
good
you.
weekend.
You
Thank you,
too.
everybody.
You too. Thank you.
Yes, we got number 8, Mr. Brewer.
Number 8, Mr. Pruitt.
And
Brewer.
Judge, this is just an arraignment. We do not need to address bond.
All right. This is 22 CR 0041938, State versus Pierre Brewer, charged with simple battery, family violence, and simple assault, domestic violence, from April 18th, 2022. Mr. Brewer, you've been advised, you have a right to remain silent, and anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Finling. Mr. Finling, do you waive a reading of the accusations?
Yes, Judge.
Upon your entry of a not guilty plea, Mr. Brewer, your case will be scheduled for trial. You are legally presumed to be innocent of the charges, and at the time of trial, the state has the complete burden to prove the charges against you beyond a reasonable doubt and overcome your legal presumption of innocence. If the state does succeed, you will be convicted and sentenced to up to a year in prison and or up to $1,000 fine for each convicted offense. Given this information, how do you plead? I heard not guilty. Is that correct?
Yes,
I
ma'am.
heard, was that correct?
Yes, ma'am.
This case is arraigned and further notice for trial. Thank you, Mr. Brewer. Thank you, Mr. Findlay. Courtroom 2, who do we have?
Position 4.
Hang on, 4 South. No, I'm going to alternate 4 South, but both sides have been waiting. Give me a moment. Courtroom 2, who do we have?
This is an add-on, position 4, Mr. Granville.
Man, I tried to talk to that lady the other day. Man.
Ooh, mute 4 South, please. Thank you.
I don't understand why.
Wait, Judge, I thought you were doing courtroom 2.
I am doing courtroom 2.
Oh, okay. My bad. Okay, but this is add-on, position 4, Mr. Granville.
Take it, please.
All right. Miss Helen, what was your question?
Number one, there's some stuff in the chat about the warrants not being withdrawn or an Odyssey area. That just is number one. But for this case, position 4 in the add-on is one of the quarantine cases. And so we just needed an opportunity to speak to all of those people together.
No, he's not.
Yeah, that was on the previous
No,
case.
he's just a regular, he's not on the quarantine. He's not the quarantine zone. He's just on stuff, but not on quarantine.
Let me just clarify. Miss Helen, this is position 4 on the add-on calendar, Alonzo Glenn Granville. Is that correct?
Yes, Judge.
And have you had an opportunity to speak to Mr. Granville?
I have not. Can I get an opportunity to call Mr. Granville?
He just mentioned that Mr. Finley is his lawyer.
Mr. Finling, did you speak to Alonzo Granville?
I did speak with him for Tuesday's court. So yes, I actually did originally.
I apologize, Judge. I did not know that.
That's
I didn't,
okay.
I
That's
didn't
okay.
realize that until
In
now.
the thousands of cases that you all speak to, I'll allow 1 or 2 to look up like that.
Yes, I did speak with him on Monday for Tuesday's calendar.
All right,
And-
this is add-on position number 2, position 4. And do you think your client is still willing to go move forward with the plea?
Mr. Granville, I have in my notes on Monday, you wanted to move forward with the plea. Is that still the case, sir?
Yes, sir, whatever your best interest.
Sorry, can you repeat? I didn't understand you, sir.
I'm rolling with your best interest.
No, It's not up to me, sir. This is all your decision.
Yeah, I'm still willing to go with it. Go for it.
All right. So, Mr. Granville, you've been advised of your right to remain silent. Your attorney for this particular plea hearing is going to be Zach Finley. And Mr. Granville, may I place you on the oath for the purposes of the plea? Do you solemnly swear and affirm that the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right, we're first going to hear from Madam Prosecutor, Ms. Sari.
Yes, Your Honor. The recommendation in this case is 12 months to serve 32 days, credit for time served 16 days, the balance suspended, and to stay away from the incident location 2572 Lenox Road Northeast in Atlanta. Nothing further.
All right, thank you. Mr. Finley?
Yes, Judge. That is our understanding of that original offer. And we do stipulate the factual basis, venue, and ID.
Thank you. Mr. Granville, have you consumed any kind of medication or alcohol recently? Oh, please unmute courtroom too.
No, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
And you've understood everything that's been going on so far, correct?
Yes, ma'am.
If you decide to take this plea, you would have to give up your constitutional rights to go back to court, to have a trial in front of a judge or a jury, to be able to confront your accuser, examine witnesses, challenge the state's evidence, present your own defenses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass and one count of obstruction of an officer?
Yes.
Your sentence is 12 months to serve 32 days, credit for time served 16 days. If you have no other holds at the jail, then you will be released within 24 hours. The balance is suspended, but that means you have no further obligations in this case, but you must stay away from 2572 Lenox Road in Northeast Atlanta. If you return to that location, you will be arrested and brought back to jail. Understood?
Yes, ma'am.
Thank you. That concludes this case.
Thank you, Ms. Flynn.
For South, who do we
Sir,
have?
thank you.
Number 7, Mr. Blair.
Repeat again for South.
Number 7, Mr. Blair.
Okay. This is Joseph Blair, accused of criminal trespass in 20 CR 004-545F. Mr. Blair, you have been advised, no, sorry, you've not. You have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Finley. Mr. Finley, this is going to be a negotiated plea, am I correct?
That's correct, Judge.
All right. And so, Mr. Blair, if you please raise your hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do, Your Honor.
Thank you. And Ms. Sari, what's the recommendation for Mr. Blair?
Yes, Your Honor. The recommendation is 12 months to serve 20 days, credit for time served 10 days, the balance probated, a stay away from the victim's address, which is 6618 Collier Way in Riverdale, and a stay away from the Walmart located at 834 Cleveland Avenue in East Point. No contact with the victim, Shuntrice, Shuntrice, last name Bivens, and a family violence intervention course. Nothing further.
And Mr. Finley?
Yes, Judge. That is our understanding of the offer, of which we do agree. We'll just ask on Mr. Blair's behalf that once he does complete that family violence course, if he could be a non-reporting judge.
Any objection, Ms. Sari?
No objection, Your Honor.
All right. Okay. Mr. Blair, have you consumed any kind of medication or alcohol recently?
I have not.
And are you satisfied with your attorney?
I am.
And have you understood everything that's been going on so far?
I do understand.
Right. If you decide to plead guilty to this charge of criminal trespass, domestic violence, you would have to give up your constitutional right to challenge this charge in a court of law. You will not be able to have a trial before a judge or a jury. You will not be able to confront your accuser, examine witnesses, challenge the state's evidence and present your own defenses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
I am.
Are you entering a plea freely, knowingly, and voluntarily?
I am.
How do you plead to 1 count of criminal trespass, domestic violence?
Guilty.
Your sentence is 12 months to serve 20 days, credit for time served 10 days. Your jail time is concluded, and if you have no other holds, you'll be released and placed on probation. You will report to probation next Thursday at 132 Mitchell Street in Atlanta, Georgia. While you're on probation, you will complete a 6-month domestic violence intervention program, and you will pay for those classes yourself. At all times while you're on probation, you shall also stay away from 6618 Collier Way in Riverdale and the Walmart at 834 Cleveland Avenue in East Point, Georgia. Once you've completed the conditions, the class conditions, your probation will be non-reporting. I will waive your probation fees for the first 6 months. Thank you.
All right, next on number 6, Mr. Benjamin.
All right. Is this Ladarian Benjamin?
No.
What's your full name, sir?
Ladarian Benjamin.
All right. Mr. Benjamin, we had called your case recently. Is this the one where the attorney waived appearance? Was your attorney Justin Spisman?
Yes, ma'am.
All right. So, Mr. Spisman, your attorney is going to file a waiver of arraignment. In other words, he's going to enter a not guilty plea on your behalf, and your bond has been amended to a $4,000 surety bond.
Yes, ma'am.
All right. And your case is going to be further noticed for trial.
Thank you so much.
Thank you.
Yes, ma'am.
Courtroom 2, who do we have?
I'm sorry, Judge. This is gonna, are we doing courtroom 2?
Yes, yes, we are.
Position 30, Mr. Sanders.
And Judge, when I went and spoke to Mr. Sanders, he informed me he does not want the services of the Public Defender's Office and would like to represent himself pro se and be led and began that process.
All right, thank you. Mr. Davius Tyrell Sanders, is that correct?
Yes, ma'am.
All right, Mr. Sanders, you've been advised of your right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one of our competent counsels from the Public Defender's Office will be glad to represent you and share their legal knowledge and their expertise so that your rights against self-incrimination and to protect your ability to defend yourself in this particular case. This case is 22 CR 004047Y, in which you've been accused of criminal trespass from June 24th, 2022. With regards to your particular case, if you waive your right to counsel, you would be required to understand how the law applies to the facts of your case, and any ignorance of the law would not be an excuse. You would also have to understand how making any statements or taking any pleas and how that could create any consequences on any other possible open cases or your personal situation. Given this information, do you voluntarily and willingly waive your right to counsel, or would you like the services of the Public Defender's Office?
The first one.
You need to repeat your response.
The first one. The first one. Can you repeat the first one again?
Which first one?
The first one. Can you repeat what you said?
Do you want the services of a public defense attorney to assist you, or do you want to represent yourself?
Represent myself.
All right. Okay, hang on. Sarge, it's rather loud in courtroom 2. Thank you. All right, we cannot unmute courtroom 2 because he is representing himself.
Hey, hold on. Judge said y'all have to be quiet right now. We got court what's going on.
Thank
Step back in. Step back in.
Thank you. Thank you. All right. As I just wanted to confirm, Mr. Sanders, you want to represent yourself, correct?
Yes.
All right. Presently, you've got a bond of $1,000 surety bond with respect to a criminal trespass from 950 West Peachtree Street in Atlanta, Georgia, which is the public supermarket. The state has made an offer that if you decide to plead guilty, your sentence will be 12 months to serve 28 days, credit for time served 18 days. The balance will be suspended, and then you would have to stay away from the public supermarket at West Peachtree Street. You can either decide to accept the plea, or you can enter a plea of not guilty and have the case scheduled for trial. How would you like to proceed?
I accept. Yes, accept.
I don't understand what you're saying.
I would like to accept.
Have you reviewed the paperwork and signed off on the information on that paperwork?
No.
Thank you.
Mr. Sanders, in your conversation with Miss Helen, have you had a chance to review the plea paperwork?
Oh, yeah, I did, yes.
And do you have a copy of the paperwork?
No. I didn't.
All right, then, Mr. Sanders, why are you representing yourself? If the attorney can complete the paperwork for you and submit it to the court. Can you explain that to me?
No.
All right, we'll take his case up last until he's had a chance to review the paperwork. And then at that time, he can decide whether he would like the assistance of counsel. Thank you.
All right, next we have position 7, and he's an add-on Simpson.
All right, thank you.
And that's a negotiated plea, Your Honor.
All right, thank you. And is our brilliant Mr. Sanders seated back there? Is he seated back there, Mr. Sanders?
Yes, I'm seated.
Yes,
Okay,
yes.
open your ears and open your eyes and watch and see what is happening. If you want to be your own attorney, you watch and see what's happening very closely. Good heavens. All right, did we say this is going to be position number 1 from the add-on?
Position 7, Your Honor.
7, okay.
Come here. Take all.
This is State versus Rayfield Simpson, case number 22 CR 004-111A. Mr. Simpson has been charged with criminal trespass. What a coincidence, just like Mr. Sanders, all right? But Mr. Simpson, you have been advised of your right to remain silent, and anything you say, your statements can be used against you. And Mr. Simpson, you have a right to an attorney, and you're going to be represented by a very able attorney, Ms. Catrice Helen. Do you see Ms. Helen on the screen?
Yes.
All right. Now, Ms. Helen, what are we doing in this case?
Judge, this is a negotiation.
All right. This is going to be a negotiated plea.
Yes, Your Honor.
It will be a plea hearing. Have you had a chance to confer with Mr. Simpson?
Yes, Judge, I've spoken to Mr. Simpson. He agreed.
I'm doing this for the benefit of Mr. Sanders.
Oh.
And have you had a chance to review the paperwork with Mr. Simpson?
Yes, Your Honor.
And has Mr. Simpson read through the paperwork, and has he agreed to a waiver of his rights?
Yes, Your Honor.
And has he signed off, or has he had you review the paperwork and sign off on his behalf?
Yes, Your Honor.
All right. And is Mr. Sanders listening, or is he not paying attention? All right, good. All right, so Mr. Simpson has reviewed all the paperwork, which we also have a copy, and which his attorney will be able to send to the court. Mr. Simpson, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Ms. Tortorello, what is the plea offer for Mr. Simpson?
Yes, Your Honor. We're offering 12 months served 26 days, credit for time served 14 days, balance suspended, and to stay away from the incident location, which is the Quick Trip at 630 10th Street in Atlanta. Nothing further from the state.
Thank you. Ms. Helen, do you stipulate to the factual basis, venue, and ID?
I do, Your Honor.
All right. Mr. Simpson, have you consumed any medication or alcohol recently? And are you satisfied with the representation you've received?
Yes.
And have you understood everything that's been going on so far?
Yeah, yes.
All right. If you decide to plead guilty to criminal trespass at the QT gas station at 10th Street, you would have to waive and give up your constitutional right to have a trial, to have the assistance of counsel so that you could confront your accuser, examine witnesses, have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights, including those that you've read about?
Yes, Your Honor.
And how do you plead to one count of criminal trespass?
Guilty.
Your sentence is time served, balance suspended. Once you are released, you cannot return to the QT at 630 on 10th Street, Atlanta. Otherwise, you'll be arrested again.
All right, I won't go back there.
Anything else?
Yeah, I'm moving to a different place, so I won't have to go back there.
All right, well, best of luck, sir. Thank you.
Thank you, Judge.
No, you're going back to him. Next is position 25, Mr. Hurd.
Thank you.
Your Honor, the state has submitted a no pros order for your review and signature.
Is it for the whole case or? Yep. This is Ricky Hurd. I can't hear you. Is this Ricky Hurd?
Reginald Hurd.
Reginald Hurd.
Reginald Hurd, okay.
Yes, ma'am.
Well, he was accused as Ricky Hurd, so we will do an AKA as Reginald Hurd. Mr. Hurd, the prosecutor has decided not to pursue prosecution in this theft by shoplifting case, so this matter is concluded.
Yes.
Thank you.
All right, next
If
we
you have
got.
no other holds, you should be released within 24 hours.
Oh, yeah, okay, thank you. That's it.
Your Honor, on the calendar, it states it's Ricky Hurd. That
Yeah, I know. That's why I'm saying he's AKA
Are you
Reginald.
known as Ricky Hurd as
My
well?
name is Reginald Hurd. I mean, what's the other name you got? I don't know. I'm saying my name is Reginald.
We got 29, Mr. Mustafa.
All right.
Are they going back to him? Yeah, this.
Yes, we have, we just have Mr. Sanders left, right?
Yes, we only have Sanders left.
All right.
No, we
We'll be-
also had those three guys back there left for the quarantine inmates that needs to be seen.
All right.
Thank
So, Mr. Sanders, do you still want to proceed pro se? You still want to represent yourself?
Put your mask up for me.
Do you still want to represent yourself?
Yes.
All right. We're going to hear your case next Tuesday. Make sure that you have all the documents to review and initial and sign them off so that we will have the documents ready when you're prepared to take your plea. You understand?
Yes, I understood.
All right. The Mr. Sanders case is reset. This is position 30 to Tuesday, and that was going to be July 19. Thank you.
29, Mr. Mustafa.
Thank you. We have State versus Takari Marquis Mustafa, 22 CR 002-586Y. Mr. Mustafa was charged with obstruction of an officer and sale of a MARTA token at a public transit on April 27, 2022. Mr. Mustafa, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your attorney is Ms. Saintflex. Ms. Saintflex, how are we proceeding in Mr. Mustafa's case?
It's a motion hearing, Your Honor.
All right. And what's the motion about?
It's a bond.
All right. So we're going to, has your client been arraigned?
Let me check his, try to see.
Yes, he was arraigned on May 19, 2022.
Okay.
And his bond that was issued on 28th April 2022 was a $600 good bond. All right. So you may proceed. And Ms. Saintflex?
Yes, Your Honor. We filed a request for a bond modification, Your Honor. As the court has noted, Mr. Mustafa
has been in since his allegation. So he's been in a total, according to Odyssey, 79 days as of today. That is almost 80 days that he's been in jail. His bond is very low. And I spoke to his sister as well as his mother, and they do not meet the qualifications that it's going to take to get his bond, done through a surety company, and they cannot afford $600. So we're asking the court for a modification based on Mr. Mustafa has been a victim to the things that are going on in the jail right now, Your Honor. I am not sure if the court is aware, but the current pay for protection scheme that has been happening, Mr. Mustafa has informed me that he was in fact addressed by several men in a violent way. Mr. Mustafa is 21 years old, and these
Your
men-
Honor, I'm sorry to interrupt, but can we please have a breakout session? I'm so sorry.
With whom?
With the court, the public defender, and the solicitor's office.
I would.
I think you might want to, if you could just oblige.
All right, Ms. Champion, if you could please place Ms. St. Flags, Mr. Walker, and Ms. Sari and myself in a breakout.
Me as well, Judge.
Can I join as
Howard.
well, Judge?
All right, Ms. Helen as well.
And Mr. Howard, I believe.
All right, so if Ms. Champion misses one,
Can you please transfer me to?
I feel left out. Now I kind of want to go in too.
And let me make sure Ms. St. Flex returns too. Okay, good. Thank you. Mr. Mustafa, based on the sidebar conference we've had, your bond is amended to a $1,000 signature bond through the jail with a release to Henry County hold only. All right. And depending on what transpires at Henry County, the release will be based on what the judge in Henry County decides. In the meantime, once you're released back into the community, you are to stay away from all MARTA property. You're not permitted to use any trains, any buses. You cannot be on any MARTA property to use their facilities, such as their bathrooms or parking lots. Understood? Thank you. This case is going to be further notice for trial. It's already been arraigned.
All right, next we got number 35, Mr. Wilkerson.
Oh, Lord. This is Jacalbert Wilkerson, accused of battery domestic violence in case number 21 CR 004871C. This is from a June 22nd, 2021 incident. Mr. Wilkerson, you've been advised of your right to remain silent, and any statements you make about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Catrice Helen. Just to confirm, Mr. Wilkerson is a gentleman at 4 North. Is that correct?
Yes, ma'am.
Do you wave your hand, Mr. Wilkerson? Good. Okay, thank you. All right, this is position 35. And Ms. Helen, we are going to arraign the case.
Correct, Judge.
Do you waive a reading of the accusation?
I do, Your Honor.
Yeah. Mr. Wilkerson, you've been accused of this misdemeanor offense of battery domestic violence. You have, upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the state would have the complete burden to prove the charge against you beyond a reasonable doubt. If the state prevails, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Yes.
Your case has been arraigned and is further notice. That concludes your case. Thank you. Courtroom 2, who do we have, please?
Judge Law, these last 3 cases that I have here in the courtroom, which is position 21, 27, and the add-on position 6, none of these are part of the quarantine crew. So we're asking if, I don't know if they can.
All right. So position 21, 27, and add-on number 6. Are those all your clients, Ms. Helen?
Yes, Your Honor.
All right. Go ahead and contact the jail and speak to your clients, and we will resume with that. All right. In the meantime, courtroom 2 will be in conference with Ms. Helen. In the meantime, Francois, we had one more probation case to address.
These are the last 3. Everybody else was quarantined.
Okay.
And I have the last probation case as well, Your Honor.
All right, let me know what's going on because he or she is not here, okay?
Do we want to do the competency calendar, Your
Yes.
Honor?
So the next thing we're going to do is the competency calendar. Ms. Champion, if you could place me and Mr. Walker, Mr. Howard and Kasha, and let's put Lori Thornton in the breakout as well.
So Your Honor, we're not done with SAP then, right?
Not quite. We have the 3 cases still to be addressed.
Okay, no problem. Thank you.
Mhm.
Hey, courtroom 2, I'm trying to give you guys a call. If you could answer the phone if you guys are there.
What you say, Helen?
I said I was calling, what's the number for courtroom 2 again?
Yeah, it's 404-612-2392.
Thank you.
All right, do we have someone here for? Who was it, Kasha? Someone's waiting on,
Wow, you ready to go back?
someone here is on a Zoom user. I see someone in a black cap.
Let's talk to somebody else, but do you understand what I'm saying?
Yes, ma'am.
You have.
All right, courtroom 2, yeah, please. There's a lady there.
Hi, I'm waiting on Mario Bibbs.
Mario Bibbs, yes, okay. So, I've already had a conversation, and his case is going to be addressed on July 28th. And I'm going to place you in a breakout room with Miss Kasha. Miss Kasha, could we just share the information that we did about why we're resetting him to July 28th and what the family needs to do to reach out to Mr. Bibbs?
Okay, will do.
All right, thank you. Ms. Champion, if you could place Zoom user and Ms. Kasha in a breakout, please. Thank you. And three.
Nadia Robbins, can you put me in the breakout room too, please?
All right, are you a family member as well?
Yes.
All right, Miss Nadia Robbins and Zoom user with Miss Kasha. Miss Kasha, please have them identify themselves to you before you proceed.
Will do.
Thank you.
And
All right.
Your Honor, I
Yes,
have a
Ms.
few
Love.
announcements, if I can.
Yes, please.
Yes, Your Honor. Position
you
20.
have- Yeah, go ahead.
Position 21 is a reset to July 19th, Your Honor.
Okay, position 21, that's Nico Flowers.
Yes, Your
That's
Honor.
reset to July 19th, next Tuesday.
Yes, Your Honor.
Okay.
Position 22 is a medical reset to July 19th. Or excuse me, Your Honor, July 21st, just 1 week.
21st, okay. Flowers is being reset for a plea?
Possible plea, Your Honor.
All right, just gonna make
Judge
a
Law,
note.
whenever you're ready, we have position 6 add-on,
Oh,
Mr. Lewis.
sure.
And you ready for 6 add-on then?
That's mine, Judge. And yes, I'm ready for that.
All right, and Miss Helen, do you have any more cases that are pending?
We do, Judge. So position 21 is that reset.
Yeah,
Position 22 is a medical reset to July 21st.
okay. All right.
We're still holding on position 23 and 24. The jail has to get Mr. Gales.
The only person we have is position 27 and Mr. Lewis, position 6 add-on. Those are only 2 guys we have left in courtroom 2.
And Judge, I forgot you spoke to the deputy. Gales and Henry are a refusal, so we're just going to reset them 1 week. They are a refusal to come to court.
Okay, so this one's reset. Gales is reset to July 21st. And
Correct,
so
Judge.
as well as position 23. And what was the other one?
Henry.
Yeah, Mark Henry, position 26, reset to July 21st.
Correct, Judge.
All right, let me get to position number 6, add-on, and that is Rayfield Simpson, is that correct? Are you Mr. Rayfield Simpson, 3 cell?
This is in courtroom 2.
This is the
Courtroom 2.
add-on,
that-
Judge.
The add-on 5?
Oh, add-on 5.
I think it's add-on 6.
Oh, add-on 6.
All right, my mistake, I was reading the wrong page, sorry about that. Add-on 6, we have Kalen Lewis.
Yeah, definitely.
All right, Mr. Kalen Lewis is case 22 CR 004125F. And Mr. Lewis has got a charge of criminal trespass from June 27, 2022. And what are we doing, Ms. Helen?
That's mine.
Oh,
Your
Mr.
Honor.
Finley, excuse me?
Yes, Judge. Those going to be a negotiated plea.
All right. Mr. Lewis, you have a right to remain silent about the facts of the case. Any statements you make, your statements can and will be used against you. You have a right to an attorney, and Mr. Zach Finling will be representing you. May I place you under oath for purposes of the plea?
Yeah.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Tortorella, what's the plea recommendation for Mr. Lewis?
And just to clarify, is the defense accepting the global offer?
Yes.
Okay, so Your Honor, for case number 22 CR 004125F as in Frank, for the criminal trespass charge, we are offering 12 months, serve 12 days, credit for time served 12 days, balance suspended for the defendant to stay away from the incident location, which is the Wildwood Parks Apartments at 405 Fairburn Road Southwest in Atlanta. 21, the next one is 21 CR 006805C. Will run concurrent to 22 CR 004125F for criminal trespass. That he has 2 counts, criminal trespass and theft by shoplifting. For the criminal trespass is time served and to stay away from the incident location at the Citgo, which is 490 Fairburn Road Southwest in Atlanta. And for the theft by shoplifting, it's time served. Nothing further from the state.
All right, so we are addressing 2 cases from Mr. Lewis, the 22 CR 4125F and then the 21 CR 006805C, criminal trespass and theft by shoplifting. All right, understood. Mr. Finling, are those the terms to which your client has agreed?
Yes, Your Honor.
And do you stipulate to the factual basis, venue and ID for both cases?
Yes, Judge.
All right. Mr. Lewis, have you consumed any medication or drugs recently?
No.
And have you understood the proceedings as they're going on so far?
Yes, ma'am.
Do you understand that we are addressing 2 open cases against you?
Okay.
Is that your understanding?
I do, I understand.
One case involves criminal trespass at the Wildwood Park Reserve, and the other case involves trespass and shoplifting at a Citgo gas station.
All right, we can you can help me stop that second charge from happening by getting in contact with this bank named Shine.
Mr. Lewis, I'm not stopping anything. I'm just trying to get you to understand that we are addressing 2 open cases against you.
Cool.
And that if you are entering a plea of guilty, then you'll be required to stay away from both these locations.
All right, I agree. Yes, ma'am, I'm very guilty. I plead guilty, like I just raised my hand.
All right, before you plead guilty, let me check on certain things.
All right.
Are you satisfied with the representation you've received from Mr. Finley?
Yes, but not with the deputies here at the county jail.
That's not what I asked you. I asked you about the attorney. I didn't ask you about the deputies. So if you can focus on the questions. Are you satisfied with your attorney?
Yeah, I'm very satisfied.
All right. And if you, is anyone forcing you to enter a plea of guilty to these cases today?
No.
And if you decide to take a guilty plea, have you gone over the rights that you have to waive in order to enter a plea?
Oh, trial. Yes, ma'am. I waive the right to trial. Yes, ma'am.
All right. And do you have any questions about your rights to waive a trial?
No.
And do you understand that you'll also be waiving your right to challenge the state's evidence, to present your own defenses, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt?
Amen. We agree to that.
Are you waiving all these rights?
Yes, ma'am.
How do you plead to 1 count of criminal trespass from the 22 CR case 4125F?
Guilty.
How do you plead to criminal trespass and theft by shoplifting in 21 CR 6805C?
Guilty.
Your sentences are time served for both cases, but you cannot return to the Citgo gas station at 490.
Oh, that's it. That's all. I need my debit card for that, man. If I can ever get some help to get the bank, send it to me. Can you tell me how?
Mr. Lewis? Mr. Lewis, if you could.
Listen, it's because of information that I don't know, a phone number and the last 5 expenses, that I'm homeless and without $15,000. It's on a debit card that I lost.
Mr. Lewis, you're getting time served and no probation. If we could move forward with the
all right, I agree.
The plea. Thank you, sir.
As I was saying, Mr. Lewis, you must stay 200 yards away from the Citgo gas station at 490 Fairburn Road. You're not allowed to return in the store. You cannot be on the parking lot. You cannot be on the sidewalk. And if you return, you'll be arrested for criminal trespass again.
All right.
You cannot return to the Wildwood Park Reserve at 405 Fairburn Road. If you return to that park, you return to the sidewalks or the parking lots, you will be arrested again.
And Your Honor, that's an apartment. I'm
Oh,
sorry.
I'm sorry. That's an
My
apartment
property
complex.
is $3 million. It's just boarded up right now because someone's trying to interfere with it.
You cannot return to any of these locations.
All right, but I remember what you said. And plus we're being recorded. I remember that.
That concludes this case. Thank you.
Jeez.
Our cases.
Thank you, Judge.
Come on, Mr. Lestrap. Next is position 27. Have a seat over there.
And Judge, when I spoke to Mr. Lestrap, he would like to move forward as a pro se and would like to be led in that process and decline the services of Public Defender's Office.
All right. Has he reviewed the paperwork for a possible plea offer?
No, Your Honor.
All right. Mr. Lestrap, we're going to forward the paperwork to you and you're going to review the paperwork, and if you agree to them, then sign off on them and we'll address your plea next Thursday on July 21st.
What does that mean,
Keep
ma'am?
your mask on, sir.
That means that if you want to proceed pro se, I don't think you've had an opportunity to review the plea paperwork. The paperwork in which you have to read and understand what you're waiving, understand the rights that you otherwise have to go to trial, and also understand the terms of the plea offer that's been made by the prosecutor.
I told Ms. Helen I wanted to represent myself. and
Understood. So do you have the paperwork ready?
No, I didn't. No one has any paperwork for me, right?
Understood, because we have to give you the paperwork for you to review and sign off, and then you can send it back to the court. Because without that paperwork, I cannot proceed with your hearing.
Where's the paperwork?
Well, we'll send it to you. Miss Helen, do you have his plea paperwork?
I do not, Your Honor.
Who has them?
I can send those documents to the deputies, but I don't have a plea form for Mr. Lestrap.
Weren't you originally representing him?
I was, Your Honor, but this is a part of the quarantine group.
All right, so if you have the plea paperwork, or Miss, who's it, Miss Tortorella, do you have the plea paperwork for Mr. Lestrap?
I can get that ready, Your Honor.
Okay, please make sure they are sent to Mr. Lestrap as well as to our other pro se, and that was position 30. Mr. Davius Sanders. All right, is it Deputy Francois in courtroom 2?
Yes, Judge, I'm here.
All right, could you put your email to Ms. Tortorella?
Is there a way that they can just come to the jail? Because we still got to get ready for our 2 o'clock calendar, Judge.
Oh,
They're not going to be seen till Tuesday. I mean.
I can't take the pleas right now because they haven't seen the paperwork.
Yeah, I know. I understand. That's what they said, that they're going to be seen until next court date on Tuesday.
Mm-hmm. No, next Thursday, July 21st.
Right. Is there a way that they can just bring it to them?
The prosecutors don't bring them, only the public defense attorneys.
Yeah, I'm talking about Miss Helen.
Well, so Judge, if he gets reset till Tuesday, I can bring those forms out and actually speak to Mr. Lestrap, but again, today.
That would be,
Hey, Francois.
yes.
It's sent to your email. You're going to print it off. You're going to get it to him, give him to sign. That's how it's going to work. They're going to send it to you. You're going to print it out for them so they can sign it, so we get it going.
All right. Yeah, Francois, I think that's the only way. I cannot require the public defenders to do it since they have waived their right to counsel.
Okay.
What's going on?
Ms. Okay, just put your email in the chat to Ms. Tortorella for position 20, and Ms. Tortorella send the plea paperwork, including the waiver of counsel, to Deputy Francois in the email she provides you. Make sure one is for Mr. Lestrap and the other one's for Mr. Davis.
Yes, Your Honor.
Mr. Sanders, excuse me.
Miss Yana, I'm pleading.
They're also going to be seen for court on Tuesday, correct?
No, on
Still have to
Thursday.
be done On Thursday, so they're still not gonna be able to get done for today, correct?
They're done. They will be seen next Thursday. You just print out the documents and give it to them.
Yana, I was pleading out for a guilty plea, so that means I get out today, right?
No, she said
No.
it's not gonna be done till Thursday, next Thursday.
So I gotta come back to court.
You're coming back to court on Thursday.
All right, that concludes the case. Thank you.
Okay, we got number 32, Mr. Swindle.
And Judge, that's a negotiated plea.
All right, thank you. We have State versus QC Tariq Swindle, case number 20 CR 005-221F. Mr. Swindle's been accused of criminal trespass and damage to property from January 4th, 2020. Mr. Swindle, you have a right to remain silent, and anything you say about the facts of the case, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Catrice Helen. This is a negotiated plea, so Mr. Swindle, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Tortorella, what's the plea offer for Mr. Swindle?
Time served, Your Honor. He served, I believe, 73 days.
All right, thank you. Ms. Helen, do you stipulate to the factual basis, venue, and ID?
I do, Judge.
Thank you. Mr. Swindle, have you consumed any medication or drugs recently?
No, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
If you take this plea, you would have to give up your right to go back to court, to have a trial, to confront your accuser, examine the state's evidence, and be able to have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to the one count of criminal trespass causing damage to property?
Guilty.
Your sentence is time served. That concludes your case. Thank you.
Thank you, Judge.
I got number 28, Mr. Mills.
3 South, do you have someone else?
Yes, 28, Mr. Mills.
Okay.
Well, matter of fact, I got Mr. Ferrer right here right now for probation.
I'm sorry, could you, this is position 28, Maurice Mills, is that correct?
No, I got, well, yeah.
All right, we have a switch around. Is this Mr. Farrell?
No, this is Mr. Mills, not switched him out.
Yes, Mr. Mills.
Okay, are you Maurice David Mills? Are you Maurice David Mills?
Yes, ma'am, I am.
This is case 22 CR 004135E. Mr. Mills has been accused of criminal trespass, 2 counts, on June 28, 2022. Mr. Mills, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Catrice Helen. Ms. Helen, is this a negotiated plea?
It is, Judge.
All right. Mr. Mills, if I may place you under oath, do you solemnly swear and affirm the testimony you provide for this plea hearing will be the truth to the best of your knowledge?
I do.
Thank you. And Ms. Tortorella, what's the plea offer for both these charges?
Your Honor, for count 2 of criminal trespass, 12 months, serve 14 days, credit for time served 14 days, balance suspended, and for the defendant to stay away from the incident location at Citgo, 655 Cleveland Avenue Southwest in Atlanta. For count 1, criminal trespass, 12 months, served 14 days, credit for time served 14 days, balance probated, 40 hours of community service to stay away from the incident location, and that count will run consecutive to count 2. Nothing further.
All right. So pretty much it's already suspended for count 2. And so he will kick off once he's released with probation on count 1. Is that correct?
Correct.
Okay. And Ms. Helen, do you agree to these terms? Does your client agree to these terms?
Yes, Your Honor.
All right. And let me see. And do you stipulate to the factual basis, venue, and ID for both charges?
I do, Judge.
All right. Mr. Mills, you have 2 counts of criminal trespass both involving the Citgo gas station on Cleveland Avenue. Do you understand that?
I do.
All right. And you'll be on probation for one of the charges, and you're going to be required to stay away from that Citgo gas station at all times.
Understood.
All right. Have you consumed any kind of medication or drugs to influence your decision-making today?
No, ma'am.
And are you satisfied with the representation you've received?
Absolutely.
And is anyone forcing you to take a plea today?
No, ma'am.
If you decide to enter a plea of guilty to these charges, you would have to give up your right to go back to court and have a trial in a court of law. You will not be able to confront your accuser, examine witnesses, challenge the state's evidence, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 2 counts of criminal trespass?
Guilty.
On count 2 is time served, and you're to stay away from the Citgo gas station at 6055 Cleveland Avenue. Count 1, criminal trespass, the sentence will be consecutive to count 2, and that is 12 months to serve 14 days, credit for time served 14 days. You'll be released within 24 hours, and you must report to probation next Thursday at 132 Mitchell Street in Atlanta, Georgia. While you are on probation, you will stay away from the Citgo gas station on Cleveland Avenue, and you will complete 40 hours of voluntary community service hours at any nonprofit agency except a school and except a religious organization. Understood?
Understood.
You will report to probation every month, and I will waive your probation fees.
Your Honor, just to clarify, he has a hold out of Gwinnett County. That's the reason why I did the consecutive. He won't be released immediately.
I see. Okay. So once you are released, you'll be transported, or Gwinnett County will come pick you up because you've got a hold in Gwinnett County. Once that case is resolved and you're released, then you must report to probation. Understood?
Understood.
All right. His probation time is told until he reports to the Fulton County probation. Thank you. All right. Yeah, that's good.
Thank you, Judge.
Correa for the probation counter.
Honor, I still have not received an email from the sheriff's office. I'll look it up in Microsoft to see if I can look her name up.
Okay. And we have, who do we have? I'm sorry, is this Mr. Farrell?
Yes, ma'am.
All right. This is James Darren Farrell. He's got a probation revocation in 18 CR 009 600B. Mr. Farrell, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Catrice Helen. So we have Officer Harris, who's been sworn, and she's our probation officer. Ms. Harris, why are we seeking a revocation?
Your Honor, Farrell was sentenced to probation on February 9th, 2022. He was to complete 40 hours of community service and a shoplifting course. Mr. Farrell has failed to report to probation and provide us proof of those conditions. A previous revocation hearing with Judge Porter was on May 25th, 2022, which he failed to report, and that's why a warrant was issued. Mr. Farrell's case has 8 months and 2 days remaining. Probation recommendation is to continue him on probation.
All right. Ms. Helen?
Yes, Judge. When I went down and spoke to Mr. Farrell, number one, he knew he had probation, but he thought it was non-reporting. Unfortunately, when I asked him about the other conditions, he was not aware of the other conditions, but when I spoke to him, he is willing to complete the conditions as stated by probation and be continued on probation and complete it successfully, Your Honor. But as you can see, he's in a wheelchair. It does make it hard getting to and from places. So he mentioned that was just a disability for him getting to probation. But Judge, he understands the seriousness of it. He's been confined for 8 days for this violation. Again, we do hope that you go with the recommendation of the probation office and continue him on this and give him the opportunity to complete those conditions.
So I'm looking at the disposition sheet when he was took the plea before Judge Morrow, and it doesn't say anything about non-reporting. And so, Mr. Farrell, I do not know where you got this understanding from. I'm going to accept the probation's recommendation and that you continue on probation, but I'm not going to give you any credit for the time that you've been in jail. You will report to probation next week on Thursday, and you will report every month. You have about 8 to 9 months to complete your probation, and you will report every month.
Yes, ma'am.
I will waive your probation fees, and within 30 days of being released, you must show proof that you have enrolled in an anti-shoplifting course.
Yes, ma'am.
By your second probation visit, there must be proof that you have enrolled in the shoplifting class and that you have started on your voluntary community service with any nonprofit agency. You can go to a library, you can go to an animal sanctuary, I don't care, or to a park, I don't care, but you must show proof that you've started.
Yes, ma'am.
I don't have any patience for individuals who claim they don't understand what their plea was.
I understand.
All right. You'll report to probation next week at 132 Mitchell Street in Atlanta, Georgia.
Thank you, ma'am.
Thank you.
Thank you, Judge.
All right. 3 South, do we have anyone else?
Do we still need Ms. Fulbright?
Who do you need?
I mean, I'm asking, do we still need Ms. Fulbright?
Ms. Fulbright?
Me too.
Position 2.
22.
22 is a medical reset?
Okay.
Okay, so I guess not. Thank you, officer.
No problem.
All
Is
right.
everybody right?
Yeah, we're done. Thank you.
Excuse me, Your Honor, that
Ms. Harris, did you have anyone else to address?
no, Your Honor.
Okay, if you can forward the paperwork to April Champion, she'll make sure I get them.
Yes, Your Honor.
All right, thank you. And officer in 3 South, if
Yes,
you have Francois's email, could you please put that to Miss ASG Tortorello?
Yeah, I did.
All right, thank you. All right. Okay, on the probation cases, folks, I have continued all 3 on probation. So that takes care of that. On the add-on calendar, position number 1, Barna was a plea. Position number 2 and 3 have been arraigned and further notice for trial. Position number 4, Granville was a plea. Position 5 on the add-on Jackson. What is the, did we take a plea on Shakir Jackson? I don't think we did. Miss Helen, is that your client?
That is, Judge, and I don't believe Mr. Jackson was brought.
Okay, we're going to reset him to Thursday, July 21st for a possible plea. Position 6 was a negotiated plea, that was Kaylin Lewis, and position 7, Simpson, was a plea. All right, that's the add-on calendar. On the regular SAP calendar, position 1, Anderson was a position 1 and 2, Anderson were pleas. Position 3, Sean Anderson was reset to the competency calendar. Do we have a date?
I do not believe so, Your Honor.
All right, let's reset him to the competency calendar for July 21st. Would that be all
Sounds
right?
great.
Okay.
Sounds great.
All right, so
Could
he'll
we-
be reset, position 3 is reset to competency at 11 a.m. on July 21st. Position 4
Judge,
was, yes,
Judge Law, could we push that one out a little bit further? Because I'm going to be submitting the evaluation today. So probably,
oh, okay.
yeah.
So 28, I'm thinking August 3rd then.
Yeah, we could do August.
Oh, excuse me, August 4th, 8/4. April, let's amend reset competency to August 4th for Sean Anderson. 11
Okay.
a.m. Thank
Okay.
you. All right, position 4, our seeker is represented by Mark Shardy, I think. And if this case has been arraigned or waiver of arraignment will be filed, and the bond request was denied. So position 5, Barner was a plea along with the add-on position. Position 6, Benjamin is waiver of arraignment, and he was represented by Mr. Spisman. Bond was amended to a $4,000 surety bond. Further notice for trial. Position 7, Blair is a plea. Position 8, Brewer was arraigned and further notice for trial. Position 9, Bergen was arraigned and further notice for trial. Position 10, Stephen Coleman was arraigned and further notice for trial. Position 11, same announcement. Position 12, Roger Crane is a medical reset to July 21st. Position 13, Daryl Davis is reset to July 21st. I don't have a reason, so this is just the announcement from Mr. Findling. Position 14, Desiree Davis is released, and this will be further notice for trial. Position 15 is a waiver of arraignment. Well, 15, 16, and 17 is a waiver of arraignment and further notice for trial. Bond amounts were set. So I think it was 3,500, 5,000, and 5,000. Okay. Donaldson, position 18, is a waiver of arraignment to be filed and is further notice for trial. That's Miss Rockwell's case.
And Your Honor, briefly, I know that the decision has already been made, and that's fine. There was a little bit of confusion because that warrant had actually been canceled or terminated last year, but Mr. Jordan did clarify in the chat that the warrant was erroneously voided. And that's why the defendant was picked up on the warrant.
Okay.
So I just wanted to make sure we're on the same page. That's what happened.
It's something that he's going to be addressing with the prosecutor's office. But in the meantime, Ms. Rockwell is submitting an order, hopefully reinstating his bond status to when he
Correct.
applied for a bond company. Okay.
Correct.
All right. So moving on, position 19, Mr. Fambro is taken a plea. Position 20, Fields is arraigned and further notice for trial. 21 is reset to July 19 for a possible plea. 22, Fulbright is a medical reset to July 21st. Position 23 is reset to July 21st. Gales, I believe, I can't remember the reason, I'm sorry. Oh,
Yes, 23 and 24 are reset.
refusals, they're refusals, that's
Yes,
right.
ma'am.
Okay, so July 21st for Gales, 23 and 24. 25, Reginald Hurd was null prost. 26, Mark Henry is reset to July 21st, he refused to show. Andre Lestrap is deciding to move forward pro se, so his plea is going to be addressed on July 21st. Miss Tortorello, did you get the email? No, she's not there.
I'm there. I'm here. Yes, I did. Thank you.
All right. Maurice Mills, it was a plea, that's 28. 29 is arraigned and was further notice for trial. Position 30, Sanders is reset to July 19th for a possible plea. Oh, this is the other pro se. I'm sorry, this is reset to July 21st. And again, you have to email the documents to Francois to be given to Mr. Sanders.
Yes, Your Honor.
Wilbert Stevenson, position 31, is released, and so further notice for trial. He was released on July 9th. Position 32, Swindle was a plea. 33, Quentin Tumbling was released on July 9th, so he is a further notice. Position 34 is arraigned and further notice for trial, bond amended to $750 surety bond. Position 35 is arraigned and further notice for trial. 36, Wingfield has been arraigned. No, he didn't show up. Did he show up? I don't recall. Miss Helen, that was your client?
Judge, no, that person wasn't brought.
Okay, so we're going to reset it to July 21st for arraignment. And position 37, Joseph Umis is reset to July 21st. No idea why. Ms. Helen, do we have?
That's for a social worker visit.
Oh, okay. All right. Anything else to address?
Yes, we still have Mr. Pay. He's the non-jail plea calendar that we have for today. It's my understanding that the paperwork has been completed and submitted, and we just need to go take the plea.
All right. And there he is, Mr. Jarvis Pate. Okay, you've received the paperwork?
Yes.
Yes, Your Honor.
All right, okay. Mr. Plate, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. Mr. Walker, my paperwork's all messed up. Could you please sound out the style of the case?
Yes, Your Honor. And case number, I'm sorry, I'm working from my phone today. From case number 22 CR 003377F, with Mr. Pay is being charged with 1 count of simple battery family violence. The state's recommendation is going to be 12 months probation with the condition of a family violence intervention program, no further contact with the victim, Bionica Watts, and there is no objection to non-reporting upon completion of the FIP course.
All right. Mr. Pate, you have a right to remain silent about the facts of the case. Any statements that you make could be used against you. You have a right to an attorney, but as I understand, you have waived your right to counsel and proceeding pro se. So if you please raise your right hand, do you solemnly swear, or did I already swear you in? No.
Yes.
Did I already swear you in?
You asked me to raise my hand once before?
Yeah, did I place you under oath?
No, ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
You have reviewed the paperwork and especially with the waiver of rights?
Yes.
And you understand that if you take this plea today, that you would have to waive your constitutional right to go back to court and have a trial along with all the other rights associated with having a trial in this case?
Yes.
And especially you'll be waiving your right to have the state try to prove the charge against you beyond a reasonable doubt. Is that correct?
Yes.
And Mr. Pate, are you entering this plea willingly, knowingly, and voluntarily?
Yes.
And do you understand that in entering a plea that you are agreeing that the factual basis of the charge brought against you, the venue that is Fulton County, and the ID of the perpetrator that is you are all true and correct?
Could you repeat that?
If you take this plea today, then you must stipulate that the factual basis of this allegation brought against you, the venue of the allegation of the charge, that is Fulton County, and the identity of the perpetrator, that is you, are all true and correct?
Yes.
All right. How do you plead to the 1 count of simple battery, domestic violence?
Guilty.
All right, I accept your guilty plea. Your sentence will be 12 months to be served on probation. While you're on probation, you will complete a domestic violence intervention program. It is a 6-month-long program with weekly classes, and you'll be paying for those classes. You must enroll in that program within 60 days from today. Understood?
Yes.
And at all times while you're on probation, you are to have no further contact with Biana, was it Kendall?
Bionica Watts.
Bionica Watts. All right. That means that you're to stay 200 yards away from Miss Kawatz. You're not to communicate with her in person, not through a phone, not through a cell phone, not through a computer, not through social media, and not through a third party. Is that understood, sir?
She just stood in court and asked y'all, could I start being involved in my daughter's life again?
I'm going to allow for a third party transfer of the child, which means that a third party must be appointed in order to communicate and have visitation and custody of your child. Now, if you don't want to go down the third party route, then you can file a separate legitimation action with the Fulton County Superior Court, if that's where the child resides in Fulton County, and you can obtain a court order to establish visitation and custody. I'll give you the option of either filing a legitimation action or to have a third party appointed to assist with visitation and custody. You yourself personally cannot go and pick up your child or contact Ms. Gawat to discuss visitation and custody.
All right.
All right. Like I said, the other option is go through court and file a legitimation action and obtain a court order establishing your visitation and custody. All right. You will report to probation every month. Your first 7 months of probation fees will be waived. And then after that, you will continue with probation and start paying probation fees. If you have completed your domestic violence intervention program and produce a certificate, then after that, your probation will be non-reporting. Do you have any questions?
Can I ask the court, that probation be suspended once the class completed?
I'm not suspending probation. I'm making it non-reporting, which means that if you complete all the classes, you don't have to report. But if there are any other violations, then you will be subject to a probation revocation.
Okay, I just was asking, 'cause I've basically been on probation 2 years for this case.
You've not been on probation for 2 years.
I've been
You only
reporting
are
to a
on-
burning
you are
company for 2
only
years about
on,
this case.
listen, you only get on probation once you are convicted. And this taking this plea is a conviction. You were on pretrial services. That's a different.
I understand. I'm ready for this to be over. I understand, y'all.
All right. While you're on probation, you're not to consume any illegal drugs and no weapons and no firearms. All right. That concludes the case. You will report to probation next Thursday at 132 Mitchell Street.
All right.
All right. Thank you. Mr. Walker, if you can forward the paperwork to Miss April Champion, that would help facilitate matters.
I could do. Mr. Jordan has, but I can do it right now.
Okay.
I already have it, Mr. Walker.
Okay.
Okay.
Great. I said that. All right, folks, have a real quick lunch and we will see some of you at 2 p.m. Thank you.
All right. Thank you.
Thank you.
Thank you.